and the time you go on the system infection. With last week, we still 27 there's a direction of the regulated activity demolition of something from the specialized. Ballot application tomorrow after but we start show you give us it. We can only press button. It's that set C which is the city is the language of it's the ballot. Almost let us see. Next. Yes, well. Which of which year? Of which year? Appeal. What's appeal? There are many old appeals which are there. Let us see. We'll sit together one day, just pass on the sleep. You say the content of an application in connection with the content application. Because by frustrating the post of when they're writing the audio, you also have been totally first. You just pass on the sleep and see this. Yes, sir. Yes. What is the name? Appellant. Yes. Yes. So Mitro, the senior Mr. Mitro is up. I will keep my promise. We sat 10 minutes late. I will be able to get mine. And the second promise I will keep. No interaction.
May I request Mr. Mitro to refix his microphone?
Oh, please. I think the system is, I tell you, Mr. Mitro, the moment you go farther from the microphone, the audio system does not work. If you come closer, then I think Mr. Mukherjee would be able to.
I mean, just put it in front of your face.
No, it is in front of our face, but more closer.
Grateful Lordship. Otherwise, I can't hear him.
I wish you had come closer to me.
Yes.
Lord wanted me.
Why I do not know why he has decided not to come. Yes.
That I have already covered 3 points. But if the petition is not containing any amendment regarding new execution of the therefore, petition would have been rejected.
বলছে এক্সিকিউশন সম্বন্ধে কোনো অ্যামেন্ডমেন্ট নেই বার করুন
You have indicated that administration of the will has been done 281 of the settlement. That also has been not done. Affidavit of the district
পেশেন্ট কথা
22, the paper.
Yes.
And we have slightly one judgment of our 56,
Yes. Yes.
but on this ground, the petition was
এটা অ্যাপ্লিকেশন কত করে
Yes.
that point has been taken. That is evident for us that the judgment of the action of the hearing of open petition would not be progressed or made without serving the citation or special notice to each of the testamentary intestates.
Correct.
Each of it. All. Further, I cited judgment and I showed affidavit.
Yes.
That judge broken to at page 39 of the group of 8. That's how
It is pertinent. That is the word.
after we held that, you just stop. You directed either press notice and after that, question of authority.
You said 2005, volume 12, 6.
That means that on this question, whether this one of what was authorized by the doctors or other individuals. One, are there have the petition in their affidavit? One more. One.
You said everybody.
Two.
All daughters.
All the 3 daughters of my lady.
All 3.
None of them has said in everything that they are authorized. That's one number 4 to access that from them. That's one 4 has filed an affidavit saying clearly that I was not. And I did not accept it on behalf of her.
Yes.
No, before the classroom, it was clear, the service was not completed. Even with the appearance code is now clear. Even though the ability of the doctor was putting that way. That this one was right accept service of the movie on behalf of other entities. So because the matter could not have been to see that. Next is result is consequences. My plan did not know that proceedings would not provide any career to the other side and could not appear and not examine the evidence. The constitution could not cross-examine, could not appear and could not defend and could not hide, could not cross-examine. The evidence which have been laid without cross-examination is of no value. the part on that route channel. That's like one that we can say. But my daughter said, money is enough. What is enough? Other than you cannot make one place in that.
Yes.
So make one place in the 2019. And 2016, 115 is
2000.
115.
Can you repeat the citation? Can you repeat the citation?
2008, 115.
No, that is 279, paragraph 45 to 47. Noted.
2016.
Yes.
2016, column 15, Supreme Court cases, 785, page 785,
Yes.
paragraph 6. That means the Supreme Court is have given expression nullity. Six. And
Just see. Mr. Mitchell, just give me 1 minute. Just give me 1 minute. Yes.
Then in those cases, the party was present, was appearing in the matter and wanted to close the examination. That was not allowed. But in your case, in my case, it is not so. Party was not present in court to close the examination. So we did apply on that. But to that ban and be here the party did not appear. In spite of service, is not the case. Party was disabled from appearing, prevented from appearing, and taking all the consequent steps. One of them is not examination. So, in other words, because the propounder have manipulated the proceeding in such a manner that the opposing parties, there will be no opposing parties, and it will be hard exam. That is the ground. It is denial of opportunity to oppose the matter. By reason of non-service, is a gross ethics, more gross case than cross examination. You are allowed to oppose it, and consequently you could not cross examine. And what denies can be placed on the evidence on which the opposing party, if any, were prevented from cross examination by reason of non-service of that. still the fundamental. Let you when the party appears in court and want to examine, the court does not allow him to go with them. And the party which made unable to appear in court and to cross-examine should be without the penny. That she can. If that was, and in the case of that which, then notice that in spite of that we have not appeared with them. But that's not cool. They are not service. Even then, it's not attached. This point of now, may I have it? The police and new point. Next point, look at the answer by learning the argument. Yes, these are the reasons on which prophet has been reviewed. One of the reasons that the will was signed at 3 pages, and not that, not for all. But with that, judges
Passei. Muito bem.
I could overhear something is going on there, some kind of a laugh, some kind of a discussion. So I just told them to go out and have a very meaningful discussion there.
but it was very big. Use the corridor as a partner. For passage only, not for passage. In
Yes,
then,
sir.
I have this agreement. We respect the learners because the wrong approach. Learned judge has decided not to grant probate because of because his conscience was not satisfied. Because of the following factors. Because of the following factors. One of the factors was that the testator had chosen to sign the pages of the will, although he was not obliged to do so. But once having decided to sign the pages of the will, why should he stop? And sign only 3 pages and not all remaining 6 pages. These have not been explained. So the give place of suspicion. My Lord may say, Appeal Court may say, that these factors do not lead to suspicion. That is different thing. But he has not rejected the prophet on that ground that it was not signed, signed only 3 pages. This is a suspicion. He does not clear his conscience. There is no explanation. A person, a testator, having decided to sign the pages of the will, which did not oblige to do at all. Why should he stop midway after signing 3 pages and not signing the remaining 6 pages? Can you see the will? This is the factor within that suspicion which is unexplained. Not that he from that reject this factor, another factor is taken into consideration. Maybe that was wrong. If it that when there are 3 existing witnesses, why only one is there? I don't have information. There's no calling of addition witness. Do not give rise to suspicion. That is the answer argument of the other side should be that he has not rejected the probate on the ground that because of the 2, all 3 witnesses were not. No. No, he has taken 2 factors. Cumulative effect of what was that his conscience was not clear. Let us take the first ground, first factor, namely A person deciding to sign the pages of the will, why should he sign only few pages and no problem? No explanation. This is the way. I like. May have a different plan as part of the will. This is one factor. At least in one case, because not putting all may not give rise to suspicion. I do not argue. Then that people may say, yes, he may not one will not. And it not saying of beginning not give rise to any suspicion. That argument he made, I can answer. This is the argument one can make. But not that we were provided due because that all three witnesses were not. That the center of university is a long approach in the part of that. Now the then comes the question the holography. The holography. And therefore, there is no it's the genuine example of genuine. It is not a hologram. He said, handwriting, few pages are in handwriting, other are different handwriting. These are just writing of them. That is I've got to contend that place that the last line is a holography. That is voltage place. By that protons. But that is trying to come up with page 40, the last paragraph. Although there is no contention either in the claim of the petitioner or in the evidence of the petitioner,
Where from you reading?
the judgment page 40,
40.
last paragraph of the at page 40. Although there is no contention either in the claims of the petitioner or in the evidence of the petitioner, that is further, nobody or had written and excluded state will in question in presence of any against witness. That is not that. But this will do that there is against witness. The evidence stated there is an offender on the witness state will in own handwriting, put his signature in state will in his presence and in presence of other witnesses, maybe someone from general case. You are writing the hologram will running in from the pages in the presence of three persons, all sitting right, and you are writing them. Running into about 9 pages from the entire set. 14 pages. That you weaknesses. Sitting there and start. Now come, I start. I think I if others stated that he took his together with this is not as per his instruction. Then, what we have to mention here, the design of this, petition did not try to prove the execution will in question by examining that two other witnesses of the witness. In that context, if one witness says that it was signed, it's an individual written and signed the presence of all three witnesses together, then why not call the other two witnesses to corroborate that statement? In that context, here, that it was appropriation of the state to call the other two witnesses, at least to corroborate it. But one of them has said that it was written and signed in the presence of. Number 10 in the last paragraph at page 41.
Yes.
Page 41 below my class. Correct my mistake. On careful reduction of the record and the weight of the letter, not only that is the also there are total 8 pages of the weight, not in question, but only 3 pages out of the 8 pages where the signature of the statement which has been identified and agreed by EW1. It is the non-petition. No expression why it is need we decided to start the pages of the witnesses for the obligatory. Why do we stop the signing only on 3 pages, not remaining? I know that a person trying to sign the paper we in all the pages or none. You need or you have signed none of the pages in the last page. It's not obligated under the law or anywhere. That they said they must sign all the pages. They said they must agree to the last page of the will and in the manner that is indicated. Either in the presence of identity witness or they are not calling the identity witness that they think that this is my signature. I acknowledge my signature. I think well asked. Number I see page 42. Other suspicious I don't know. The first 2 pages of the same will in question. And the remaining 6 other pages are written in different ink. And the submission made to announce it that it is incorrect. I don't know. I was not there in the beginning. But no permission. In the beginning, you want to appeal and they say, this is a long time. 2 different meanings. Appears to be not in the same number. It's it. Now, beloved, let us see what the back of the P is the challenge. This is the finding of fact. It is the challenge memo the P. Singular memo the P is the big number. I request the challenge from down. Based on the and I show that ground where you have said it's the wrong one. Based on the And I became a son. Because my junior, I said, yeah. Yes. I am and it becomes challenge in a and not in order. So then how that it would come? Proceed on a different thing. No, because all is same, all in the same handwriting. That's why syllabus report is because of the holograph way. Down number 9, sorry. The carries it down number 9 with immediate that is different. Down number 9, page 15. On the London rather asking shout. The authenticity of the week. Only because they must be different thing. We decide is wrong finding and not. Then, background said for that Lalit rather than casting doubt on the content of the week. Only because it does not contain signature legislation. And this is in all business. This content of the week. If I the body that I think so, and it has a deposit to be correct. Although during the examination of agriculture, here repeating question has been marked we are marking but every page is any activity. This particular, those particular last two pages, written in separately, containing side of the video does not carry the description of the video. Only the other six pages mainly contain here schedule of the purpose. It is self the principle of law, and we are agreed to that. So we have that is an analyze the way that he said that particular first two pages separating containing side of the video. That is the second part of the video. And that's not their series, that's not this. They are not signing. Schedule of the two witnesses by the description. Six page schedule. There's another right. When that is done, no, this I think will wrong. Why should we? She have now seen, but I was thinking that considered to be a doubting or suspicious circumstance, raising doubt in mind. These are the factors raising doubt in his mind. Not that because of one factor, I'm rejecting them. The problem. Page 43. Page 43. So, in the absence of any signature of the distance, as well as the equity, all the business to be a question. There is justified ground prices down on the content of the pages of sale. It does not bear any signature of business already negotiated. And accordingly, other pages bearing the signature of the and attributed are not sufficient to be an authentic and genuine document. He is not saying that it was mandatory on the pages of not saying that. Say, you need a document. And in my humble opinion, just put the ground. If the of the pages were signed, that was the but when some pages come and what material pages are not signed, which part is not signed? Maybe the property part, some pages are signed. Yes, the downtown not giving that those considering the transparency in the I find nothing from where we can discussion about the objective data because not satisfied. Again, discussions about the authenticity of the reading question is not satisfactory. Right. But the reasons why he is not satisfied about authenticity and genuinity of the so the expression has been exercised by the parent by giving the ground why he is done that. Before you not all internal discussion. Unless it is already explained to you with this. And then the mission, not what I see the so when I talk in your my subject on this governmental meeting, then no ground has been made out that the distribution exercise by the learned judge on this ground are not there sustainable. That's why differently white line on all pages only why the enlightenment appears and enlightenment appears not in the same handwriting. Actually, learned by right. Let me say here. If the ground line we find and it will correct me. So that is the only whole thing that entire week was not in the handwriting of the legislator or a different man, or it was correct handwriting was. And because we learn that may have this. The testament has These are submitted that no grounds have been made of government to interfere with the discretion exercised by the judge. No grounds without conference or in the level appeal to interfere with the discretion exercised by the judge. Now, after the next, he stated testimony capacity. On evidence, online sentence that we have testimony capacity. And it's the reason of that 154 is the reason.
Yes. Yes.
Yes, sufficient food comes second, whether she, etc. Then last paragraph, have decided to execute a will. Respect of use, enjoyment, and the inheritance of the property mentioned in the schedule herein appended. Whereas I declare that clearly God has I declare that after my death, a property will be exclusively enjoyed by my son, Mujendo, whom PTO, this way is not signed. And whereas I refer to declare, refer to declare that property, capital B, mentioned in the schedule hereafter will be used, that is in this paragraph, will be used and enjoyed by my son, namely Mujendra Mujumdar, after my death, as exclusive honor thereto, his wife, grandson, and granddaughter, through my head wedlock, without transferring the demised property to any outsider excepting my other son. Does it make any sense? Does this also make any sense? And that is that goes against testimony capacity of the person. That was the scribe of the will or he was author of the will? That's the question of whether people not so much respect. Well, writing, there's a draft before him, you're copying from. Yes. It's not expected the layman to start writing a will, whereas this is draft, without there being any draft. Now, this paragraph wants to know, is it any request to my wedlock? And whereas I prefer to declare, is this many sense? With getting the property and with what conditions? I prefer to declare the property mentioned in the will be used and enjoyed
Yes, sir.
Fine.
Not in touch with me. Neither have I.
Not for that. Everything is on this. This paragraph, is not a testimony of disposition, but the sound is nothing mind. Otherwise, who is that? Getting the problem. Is Jaipur United to enjoy by nation. And then you see one another. There, you not go there. Take a language. That is it. They do not do. There, he is wife, grandson, and granddaughter. Two minds say to it. Two minds say to it. It's not a big normal of the peace. But that's not produce the grandson.
In a different roundabout,
This is that.
the genes passes on. The genes passes on.
Without transferring the device property. Absolute product, but no kind of transfer. Here, evidence of not having sound distribution. And not evidence is the evidence. It will be because they are that's it. You cannot have it then it was option. Otherwise, that's a must. Hologram or no hologram, if definitely happens, it is a must. One may be induced or persuaded. To write from a draft. Has he written with the understanding or not? But difficult, but different of this. No right of say. But one person says absolute guna, enjoy absolute guna. Anything, no right of say. Accepting to my other son and sons. He can say only my other son, not even the grandson. The next paragraph also declare my children will take progress of the will, and my next son will enjoy the property. Mention the will as Munar but no right of this position is this. And grandson, granddaughter, will also be government. So the government thing is not a government. It's not, then it is all about the will. Then when it comes to the trading of properties, then the properties, you will need calculated. That's about it without this schedule contains the cream of the property of that office. Cream. See the nature of the property. As of the property has got some see the culture property. That's on the page 156. See without daily cover. Two-bedroom flat on the first floor at number 4 Central Lane, Our Road, New Delhi, 11,000 mark. From my purchase from business license. And not to put in the morning and attended and attested two-bedroom flat and attached to a new flat purchased from Sanjay Bhargav on 24/8/2019. Same address allowed it to be. Right. But he knew the details of his property, the news which he had become. Now there is no bedroom flat, no bedroom flat of the first floor allotted to Gojindam Gojindam and attached to two bedroom flat purchased from Sanjay Bhargav, purchased from Sanjay Bhargav and the purchase of Mr. Kaika. Even in the price of it, there is a capital property 50% share in the Commerce House office. Area 298 square feet. At 2A, Connection Revenue Calculator. Depends in the value. Connection Revenue at 50% share. Commercial house, commercial house. Connection Revenue, commercial house. Institutional building, there are second capital. Institutional building, room number 801, area 6,940. 224 and 225 Acharya Jagadish on the board road. And portion of division number 68 Baligan Circular Road as per land agreement dated 1 March 1960. This is without Manasam Avenue, then Acharya Jagadish on the board Krishna building and division number 68 Baligan Circular Road as per the agreement. That is Hampshire building. Hampshire building on Baligan Park. This is the most valuable property. Again, that the most valuable. But the rest of it has also got reformed. Like on the Gadiavan property. Uttar Pradesh. These properties, capital properties, are much more valuable than essential properties, but I don't have property. That even property, my friend compared to at Kumar, where from Satyaba, allotted to my son, Gojindam. Then Asansol, this property is mentioned. Extension with third party space, the property, and then another property procedure, and the property in our again. That's also property also. That is from 160. I made it. This is the property in Tandon again. Another schedule. Hampshire Owners Society, 40 old Baligan second link. Allotted to building two. Allotted. Building is well. Very expensive. Then I execute the will and my at my residence at Tandon. Yes, sir. Without education of where we will pay 156. Absolutely. So I execute this will absolutely out of my own will. It's now there. Without any request from anybody or the version from anybody. It's right. Or it's right. Working from the without understanding. But this will very significant factor. We executed 3 deeds of gift. How many lesser properties mentioned the schedule? In favor of his son within the moon, absolutely. It is stated in the petition. And in those deeds of gift with the annex, there is no mention of any will. What damage to know. If person makes a will, we have in 2010, and the deed of gift in 2030, December 2030, and a person makes a will, 3 years thereafter, 3 years thereafter, makes a deed of gift, when they the same property, which is not valid liquid in favor of by the will. And in the deed of gift, it makes no mention of the will. So it is clear, 2030, this gentleman wasn't aware of the will, does not function of the will. Yet, will in his own hologram, writing, etc. That will he is not remembering that. He is not conscious of the will. This is the matter to be explained. This is not very important because what the effect of that, now telling the success in that. You have attention to legacies. It is specific legacy of the by deed of gift, you get the immediate disposition of the property. You have let us say, any person.
Dhoni, let us.
Then it will be attention on the list. Property go out of the way. No profit can be granted of that will. We see the fiction. Attention. Anything which has been specifically equal
Section
152. Anything which has been specifically equal does not belong to the testator at the time of his death. What has been conferred to the legacy that is, it cannot take effect. Addition of the subject matter that is withdrawn from the preparation. Operational to it. And this is shown in the schedule of assets. By a person who knows that the testator was the owner of the assets will come at the time of his death. Because he has divested of it. Give. Same that is in witness. The gift and the will.
Yes.
I am relying more on the fact that a person, the testator, Alice testator, was not even aware that he had made a will of the very same property 2 years back. He was not aware of the will. He was not conscious of the will. He execute this document called will, knowing that to be will, or it simply copied from a draft prepared by somebody else. Maybe you are the behind scribe. Also, the will means they have done it with knowledge, etc. With understanding.
Yes.
Now, please give it up what we said about that. That's the implication. Okay. But before, evidence right? Other program. I say that nobody or do that own and possess the property mentioned in the property. Infinite. Infinite. Is the gift. Very infinite. Or rather, it's the person. The new to be person. Now, yes, it has written by a person in his own handwriting. But the present, when we do it, they are not steps. They will see and ask if the right. The paragraph 8 of the affidavit evidence. I say, except the will, never agree. That's the problem. Let us see what can say about this. Affidavit evidence, chief evidence. So, any paragraph taking on the testamentary capacity, I put three. And you look at the argument, right? You go to testamentary capacity, then we just doing business at that time. We're going to the office, looking after business matter, the property, the signing document, the regular directly name of the tenant of the property. So, whenever they are very now see the other evidence, the page 28. Other companies, I guess I did on my father every month has executed one prior to the all people of the January
Sir, so can you come to page 29?
29. 29.
Yes.
What are they?
Oh, you are reading which one?
My father,
Yes.
company bond,
Can you read the full of the paragraph? Yes, full paragraph.
and my father only wants to have executed one will. Prior to that of that will, including on the property.
That you have argued.
One is not correct. Do that. If you all is talking subject, is again about the wheel was right by the legislature. That's the idea. Just right. Just right. Right. Just right. Right. First,
Yes.
after given, well, in use of translated by sun or somebody, now copy. And this copy 4 weeks on the same day. Actually, 4 weeks on the same day. At the resident the assumption. Then you go on reading. This thing witnesses to the week of my disease, other normally, but and I am not Father at the time of it was the week was physically fit and mentally alive. And was in now imposing market of money. That's the best thing. So, any concrete instance of other being of sound mind or being mentally alive, any document signed by the father, the physical capacity is not proved by statement. There is now instance has to be given. That, for example, some became the mind being. There, if it is true that I was arguing on this particular. That is an example. I signed the check. I wrote any letter to Tandon or somebody. That is statement. It is not an opinion. That is an opinion, not the evidence. My father died and was physically fit and mentally alive, but it's not mine. This is an opinion. No evidence to prove it. No evidence to prove this. It's opinion. And we have all the DNA relation and passing to this case. And the relation only upon them to their paper publication. Which paper? Article. And when we have the affidavit report, we will say, Article, we were not taken in that house, it was all the second times of India. The Putrika, the newspaper, the image of how it used to be. This is what I want to show you. Here I ask you. Look, page 29 is the only oral statement of the son's opinion. His father was no evidence, no instance of father being of sound mind or executing any document apart from the will on the next. All the signature, with the handwriting of my father, regarding handwriting, contrary page, paragraph page 30, second paragraph. My father has asked that the chief justice to put their signature in his last will, dated 30 and 10. And accordingly, attested with the signature in the will of my father. It is that was the present at the time of execution and attestation. Now we are trying to see. These are three full signatures of my father. in his last week. I know the signature of my father. As I seen him signing in different official papers. You are not present. But you are signing. Then how can you say second paragraph? My father. You are not present. Because I know, because I've seen my father's signature many times. I know the handwriting of mine.
Yes.
How can you say that the other asks at the conclusion of their signature? Is it incorrect thing? Because you are not present. This is all matters for cross examination. We test it by crossing.
Yes.
I know the signature is really that last month I have been clearly implying that you are not present at the time of execution. I know my signature, other signature. You know I state. The father sign is my business. This is all he has said. So without an affidavit evidence, no statement of regarding disability because what else? Evidence, that's a bare statement of his opinion. Without any single proof, for instance, of the father having disability in 2010. On the other hand, he has himself produced an evidence now. In 2013, before his death, father was not even conscious of making up any will. He made 3 deeds of gift. In none of the deeds of gift he has mentioned that I have already made a will, giving the property or recovering this property and giving to somebody else, giving to Mr. Hazard. No. He has not given the capital many, not very clear. But if the deed of it at least will mention, if he has conscious of making of the if he was consciously made the will, it is not expected of him to mention in the will that I have made a will governing this property. This is the fact, not that it was a very, very expected, very unusual. It gave rise to the suspicion that what is produced as a will of his Jesus right according to Son, then it was not done, executed by him consciously as a will. After it was mentioned. Now, when our lamented are untrue, these are being so with inspiration for his son, about his son. We that was it. We did not do son alone. Son's daughter, son's wife, and without any power of transfer, except whose other sons. This is the way. But the deed of gift exclusively to the son. Exclusively. So, the legacy is created for jointly for his grandson, wife, all being added by the deed of gift. Son knows it, but that's not mentioned. particular we have to do. Even at least in this start. Nobody wants, I think that was said that they saw they said that wrote out this week in his presence. In that presence. There are no steps. Nobody has said that man has not said, Athens has not said that we were in mind. They will try to put a handwriting. Then, paragraph 3 of this affidavit. This is the same way. Right. I know the signature. No. I say that I have monopoly on to be signature the bill in my presence as well as other. That what is requirement of law. Now we have paragraph 6. This is witness. It is affidavit. I say nobody for Mudra while executed the will of that while absolutely sound health and mind and after understanding the content of the signature in presence of me and others. This is really no proof. No proof. Yes, not proof. Even any single instance of proof of this is oral evidence is sure. Then one will be the notified start. Exactly what is correct. Then paragraph that is this is my next signature as an entity mutual on the last income. We try to explain as per these instructions. This is the full nominal of monthly 8 pages along with the schedule of travel and signature from the nominal law. We can identify signature of this which only the education, monthly, monthly, months of signature, months of no statement that is the business sign in its presence. He said, put everything that put that signature in the presence of nobody. That in the oral statement, he does not say so. That the signature signed in his presence. That they said is everything. Everything. But those are clearly but are not very difficult facts. Not but the fact remains, there is no evidence of testimony because only opinion of two persons. And without being corroborated by any single instance of misunderstanding. Dismissed any. Now let's come to the next one. There is another additional ground on which this petition has been dismissed. Section 276 of section 3 and 283 of section 3.
That we have already argued.
Yes, the reference of that.
Yes, we have already given. 1969 to SCC, 1990 Supreme Court, 683.
And then last one, there is a fraudulent suppression in the petition of the 3 other wills and the legal will.
That we have already argued. that you have argued. You have argued like yesterday
The-
that there is no reference. There is no
And
reference.
as it went down, about dismissal of the petition.
Order 41 will be. Petition also dismissal.
And I want to cite the judgment. 1994, one Supreme Court cases, page 1. Paragraph 5 and
Paragraph 26.
5 and 6.
1994.
1991, Supreme Court cases,
Yes.
page 1.
Yes. This is on a fraud.
A tax is not upon
The court. There the municipal record was sought to be altered, that was not there. And they did not display. They did not display.
saying that these three bills and the need of bills are material documents.
Those came from Punjab.
You now
There
say
is a case of Punjab.
that was the Justice Kuldeep Singh, years from Punjab.
Oh. I thought this he was from Punjab. Yes, yes.
Right.
Yes. Yes.
Order.
Yes.
But I have only happily be permitted to add that according to the petitioner, those other three wills and deeds of gift were material and relevant. And then it is applying on the order of the movement. Other, if we say government is no suppression of non-material, irrelevant things, I can understand. There is no suppression. But when the person himself admits that these three wills and the three deeds of gift are relevant and material, and it was in his custody, in his possession, he does not produce or suppress it from the prior court. It is not upon. And on that ground, you are going to anything else, you should be petition to the meeting. On that ground should be.
You kept your Okay. Where is he? Yes. Now your turn, sir.
Actually, I'm concerned that I am
Done.
I got the argument to Mr. And I don't.
No, he has blamed you.
So far as I have known, that agreement I have filed, that agreement I can place to the The agreement is the service. That service I have not received. Actually, that particular service was executed on me, of course. But I reacted to that. Also, the confusion created on me, and I did not participate in the hearing in spite of filing a vocal as far as. But so far as the service one is concerned, I never received any copy of the summons or the notice or whatever has been given to me. On behalf of any other legal behalf of other, only I took it for myself. I think that is when the portion that has been written by hand, then the written portion is the creation of the office server. Definitely it should have been done, but that was not written in my presence. That is not written in my presence. I have given the negative to the debit, or should be kindly take off the negative.
Read it. What do you want to say?
I have not, I mean, paragraph 3 I have said, I have not received any summons for and on behalf of the respondent Durga, Tara, Chitra, Monindra Mohan, and Rajendra Mohan Gujjar as alleged paragraph. I have not at all endorsed my writing that I received the summons notice from the court on behalf of other respondents also. The endorsement made after my signature, vernacular language by Najir of the Civil Court Asansol on 1/7/2016 has not been made in my presence. Nor did I have any knowledge about the same endorsement. I cannot write in Bengali language. Unfortunately, the same endorsement in Bengali language was made by Najib behind my back. I have no authority to register. I have no authority to receive any summons addressed to my other brothers and sisters. I have not been given any authority by any of my brothers and sisters to receive any summons on their behalf. Not only summons, I did not receive any document or article sent by post by any person addressed to my other brothers and sisters, excepting such documents, those are addressed in my name. My elder sister Durga Chatterjee resides since her marriage during 1981 addressed at Salt Lake City, Kolkata. She does not reside in Radhanagar Road border. The second sister, Tara Chatterjee, also got married during 1984. Is not a resident of India. She resides at 140 Avenue, Lake, USA, where she is permanent resident and holding the green card. My third sister, Chitra Mukherjee, is staying in New Zealand. She got married in 1988 and subsequently to marriage, she shifted to New Zealand and her address in New Zealand is 2 by 20 Vancouver, New Zealand. All my above sisters stay in their matrimonial home. None of them has given any authority to me to receive any notice or summons from their home. The respondent number 5, Monitro Mohan Majumdar, did not authorize me at all to receive any summons notice for him or on his behalf. I have never said or written or made any endorsement that I received the summons on behalf of other legal heirs of deceased Nobili or Majumdar. I say that the endorsement in Bengali was done with an intention to avoid some on the other legal heirs of Nobili or
আমি কি dispute করতেছি?
summons on me in respect of other legal heirs of Nobili or Majumdar, the concocted one and the document of service of Corona is a manufactured one and has been so done to avoid any contest of the prudent proceeding by other class 1 legal. I say that I had very close relation with my father. In our ancestral house at Radhanagar, Barnwood, it is partly 4-story and partly 3-story. The ground floor of the same building used for miscellaneous purpose. In the first floor, there are 2 independent flats where elder brother Monitro Mohan Majumdar and the youngest brother Harish Mohan Majumdar are residing in their respective flats. In the second floor, I reside in one flat, and the other flat, another brother Rajendra Mohan Majumdar resides. Father was also staying in a portion of the first floor of the same building. The family was maintaining common mess under the leadership of father and son and daughter. Soon of the daughter were there staying jointly. All brothers were having cordial relation with our father, and the father used to assist financially and otherwise to all his sons, including myself. I was favored. Will I continue?
No, yes, we are listening to you, sir.
I was favored with grant of loan from the bank against the security of fixed deposit certificate of the father, which my father had permitted to be kept as collateral security against the above sanctioned loan in my favor. During the time when the father was sitting in discussion on various aspects with me, with his son, he gave out to us that he intends to have an equal distribution of his property among his sons, as he does not intend to deprive one. The fooding and stay of the sons in the same house was totally maintained at the cost borne by our father, and I never dream of bequeathing the major portion of the property of my father by our father in favor of appellant Rajendra Mohan Majumdar alone. Our father was maintaining a commendable position in the family, and he had negotiated the marriage of all his sons and daughters, and we had no independent opinion on any issue during the lifetime of our father, as he was maintaining a very firm personality which has overpowered the independent liking of the sons. I submit that I did not engage in the advocate to represent me in the proceeding before the learned additional district and Bardwan in connection with waste numbers. I say that in none of the occasions, any of the opposite parties in the same petitioner or in the same petitioner or petition for grant of permit had hindered appearance in the same proceeding. The Vokalatama as was made a part of the court record with the signature of this deponent must have been procured from other alternative source in order to show my appearance in the same source. If I engage lawyer at least one for one day, such lawyer should have appeared in the same proceeding. It appears from the records of the learned district judge Barwa that the matter was taken up on 1st of August 2016, 28th November 2016, 25th August 2017, 27th October 2017, 3rd March 2017, 22nd May 2017, 19th December 2017, 29th January 18, 8th March 18, 30th March 18, 24th
Paragraph, what is the number? How you have verified this paragraph in your deposition?
On the order sheet I got it. On that one I got it.
Then it must be from the record which I verily believe to be true. How can it be true to your knowledge?
Because I got the copy of the order.
Means you were aware of those dates.
I came to know about the orders of the day.
Then the verification ought to have been that I made an inquiry and it appears from the record this much, and the verification would have been that these are the statements made from the record which I verily believe to be true.
Record itself, certified copy of the
See, that
entire order
was-
sheet is a part of the petition.
Anyhow, that caution must have been there.
And in none of the above dates, no lawyer represented me, which creates suspicion with regard to the Bhokala Bhokka filed in the above proceeding. It also appears that the petitioner in way even did not appear on 18/7, nor did he take any step on that day. Petitioner also did not appear on 25/8/2017 and 27/10/2017, in spite of repeated call. Still, the learned trial judge allowed the proceeding to continue without dismissing the same argument. Further, the learned trial judge had recorded that the service return being duly served except jail notice. The learned judge even did not verify whether the person who has been served with the summons had the authority to receive such summons on behalf of other opposite party defendants. Technically, the order has been passed.
I think this portion ought to have been a submission. This portion ought to have been a submission.
This should have. This should have. 1 to 10. This I can. Education.
How can you amend it?
All these are appearing from the report.
True.
Nothing else appearing
Then-
from the
Then the
your
verification,
point appearing from
then
the
the verification ought to have been.
knowledge derived from
No. It is not a knowledge, it is really what derives from the record which you very verily believe to be true.
records. Good. And the
Ought to have done. That is what is a proper way of verification.
yes, that could be. I understand that. The paragraph 10 I made some submission. The submission.
But this is also true to your knowledge. Look at it, sir, what you have
That
done.
is wrong. That
Wrongly done. Everything is wrongly done.
10 and 11 is submission.
Everything is wrongly done, sir.
Stated here, submit that the present ability.
But how can it be true to your knowledge? How can it be true to your knowledge? Submission.
This should have been submission. My opponent record is complete also. Not to the history. This is related.
So defective affidavit cannot be taken into record. We will not go into it. Because every time we are going on a very technical aspects. So we have to be very technical in approaching the case also.
No, Lordship will look into the order sheet. Then the part of the paper book.
That's the difference.
All these are narrated from the order sheet. Nothing has been said which is not in the order sheet.
So discarding this affidavit, we can go and look at the record. No difficulty.
But so
I put in the court of record, no problem.
far as the service part is concerned, I have found it available by saying that
due to my lungs. Lungs are received by me on behalf of others, is absolutely wrong.
So we treat all those statements to be true except this minor discrepancy. So we can safely proceed. We can also safely proceed from the tenet of your affidavit that the father has a disposable capacity, and therefore the testamentary capacity is otherwise proved from your end. You are said till the death he has managed the entire house costs. He has provided the 4 meals, taken all decisions. That you have said in the paragraph. So he was a man of a sound mind, having a mental capacity to do it. That is what you have said in paragraph 7. You read out, that's why it is. And paragraph 7 and 8.
Yes.
Says,
Paragraph 6.
no, 7 and 8. 8 is also, my father was maintaining a commendable position in the family.
Yes.
And he had negotiated the marriage of all his sons and daughters. And he had no independent opinion on any issue during the lifetime of our father. What does it mean?
Yes.
So the father used to take a decision for the family all throughout. If he is capable of taking a decision for the family, then he has a disposable capacity. He's a man of a sound mind. He's a man who can write, who can read, who can dispose of his property at his will. And he was a man of a firm personality, you have said so. So how can one say that he was not a man of a sound mind? You have said so, that he was maintaining a very firm personality, which he has overpowered the independent fiduciary capacity. He has overpowered. Overpowered must be one word, but you have segregated it. Independent liking of the son. Just imagine, he used to influence the decision of the son. He was a man of such firm characters.
My opinion. Nothing more. My opinion. My opinion. It's not binding on the other bigger than.
No, we go by that. That's why we have to see. So one thing you have come up very candidly that the father had a testamentary capacity. He was a man who can take a decision. That you have come up.
No, I have said that you are making a commendable mistake in the family.
No, even what power? You have used the word over. He asserted his power over the likings. Means the decision of the son was not accepted all along by him. He was a man who used to dominate.
Conduct shows you. Lord is conduct shows you. It is not that I have falsely or wrongly stated something.
That's right.
I am not of that. I mean, father was having so much of property, also he was but comment he was making which can space and others. So far as the will part is concerned, I can say that I cannot conceive that he should have made a deal.
That does not mean that he did not have a mental capacity to take a decision.
So
Only thing is
unnatural. That is unnatural conduct.
is this the law? Can you send me a judgment that unequal distribution of the property by a testator that amounts to a suspicious offence? Can you send me one judgment? I know 3 against it, but I just wanted to know one in that.
No, what I say that I cannot conceive that he would have given the entire box of barrel. Well, lots of the time, they keep the action for brutalization.
No, not necessary. Anyhow, yes. So you have maintained that so far as your stand is concerned, you have received the summons on your behalf only. You were never authorized by the others to receive the summons on their behalf. That's your firm stand. And you have said that You have engaged a lawyer, but you have not said anything that you have taken any action against that lawyer who has filed a Wakadam on your behalf. Anything, any complaint with the bar council, nothing of that kind has come up. So you have not said anything, nor you have come forward and disowned whatever the signature part is concerned. You say two other subcutaneous means they might have opted, which I gather from this. But we have not denied that the signature of Wakadam is not yours. Anyhow, so this is what you stand. That's enough. Yes, who is for the daughters? If they want to say anything. Because many things are said about you. So would you like to meet, because your scope is limited, then we'll revert back to Mr. Mukherjee in reply.
The application which I filed,
All three daughters have filed.
all three daughters.
No, any other son is left appearing. No one. No, you are representing one, he is representing another. The third one. Anybody who is there? Third one is not coming forward. Oh, it's gone. Yes.
The logical is of page 125.
Yes.
The affidavit filed by the elder one, because the elders among the all the. Page 125. 125. Page 120. Page 120.
120. Yes. Yes.
The logical is of the back of one. Last three guys. It is pertinent to mention that we have just said that it was within the knowledge of picture that the picture has incident for and really developed four brothers. The picture for the stage, the picture came to know about the execution of the four and revealed from her father while the father was undergoing treatment for lung cancer. At one, the renowned hospital Canada, it was father stated that the same he was in the cancer custody of my late father. Because the suffering from cancer, Dula Chatterjee is the only doctor who is residing in Canada. So she used to look after the father and the died mother under the care and custody of this elder daughter. That's why my name is logically considered in consonance with these, my lord, and done to paragraph 6. That is on page 120.
She is the eldest amongst the siblings. Yes.
The picture states that DPP appears September 2013. The tester of the will was diagnosed with lung cancer stage 4 and being eldest among the three daughters and four sons of the testator. He used to stay with the father and used to take care of him during the period of his illness. It is further stated that the pictures were expressed such and such. There was no objection if the instant that is allowed. So far, my lord, the will disclosed to me and disclosed to them that there is an instance of will. Four brothers were given, 400 to always the protocol is there. And three separate evidence have been filed. Yeah. Page 125 is the affidavit by another doctor.
That is Rara Chatterjee.
Yes, madam.
She lives in USA.
Yes. Another you got to find 135 by another doctor. Chitra.
Yes.
The three daughters were separately have admitted the execution of the will. And they have no objection for granting of proceedings for those wills are concerned. So far the acceptance of summons. Why not? Whether any express consent was given by consent and inferred by a conduct also.
Yes.
So that acceptance was there. We came to know the probate was filed. We did not initially did not raise the objection because we know that these are the documents. We assume the probate. By post also in principle because not been disclosed here, so I cannot make it sufficient this content. We achieve by conduct itself it proves that we have accepted the service and the proceedings initiated to the court. So, till today, my lord, it is not have any objection for granting of the writ in favor of the police. Executed by grand court.
Yes. Yes, Mr. Mukherjee. You are in reply. Please unmute your system, Mr.
For God's sufficient. Everyone. That's all.
I want, yeah, my lord, may I address now?
The I saying about the others, mental or that is not when accepting that. That can be taken note of. The ability can evidence can be taken note of at this stage. And if you lordship they want to take it, then I have a right of cross examination.
So we take it that whatever the affidavit which has come in the first appeal, before the first appeal, that should not be taken into consideration. If the court wants to take into consideration, then an opportunity to cross-examine should be given.
Not all, not all. Regarding service of the summons, that is not a procedure. But regarding somebody's mental condition, that is matter of evidence.
Yes. Mr. Mukherjee.
Yes, my lord. May it please the lordship. May it please the lordship. I think Mr. Mitra is not contending. So far as the consent of the three sisters are concerned, he has a right to cross-examine the sister. The consent goes without any cross-examination,
Yes.
even before your lordship. There is no question of cross-examining the sister. Now, my lord, all the facts are now before your lordship.
Yes.
In my respectful submission, from the entirety of the facts so placed before lordship, two distinct possibilities emerge.
Yes.
Mere possibilities, I'm only putting it that way, mere possibilities. One is a possibility, as indicated by Mr. Mitro, that there was no service at all. No service at all.
Yes.
They could not appear because of non-service before the district delegate. They could not appear because of the non-service before the district judge. And the district judge has dismissed the application for probate. Mr. Mitro's Khan has on affidavit said he accepts the dismissal of the application for probate. He has no grievance. That your lordship will find from an affidavit filed by Mr. Mitro's client in this honorable court. Has no grievance. He accepts, Lord, that dismissal of the application. The other possibility is that they were served through Ravindra. The sisters are not contesting, and they, in their wisdom, thought that it is not worthwhile to contest this proceeding, allowed the proceeding to continue as it is.
Yes.
They considered it not worthwhile to contest. They stayed away in spite of service. And, my lord, after the dismissal of the application for probate by the district judge, they were awakened from their complacency and decided to take a chance because the district judge had dismissed the application. There are two distinct possibilities. One is because of non-service, they couldn't appear. The other because they are, even after service, they thought it not worthwhile to contest the proceeding. Now, my lord, in making a choice, your lordship would have to consider, my lord, which possibility appears to be probable. They are not able to explain the filing of an Vakalatnama with the district delegate. It is suggested that I have caused that Vakalatnama to be filed. Therefore, I, being the propounder, I converted the uncontested proceeding into a contested proceeding for my advantage. This is a story placed for lordship for your lordship's consideration. Now, my lord, Mr. Bhattacharya also, Kamalesh Bhattacharya, also saying that he did not cause the application, the affidavit to be filed. This is, I am converting. The propounder is converting an uncontested proceeding into a contested proceeding by filing a fourth vocalatama. That's for your lordship to consider how far this story is acceptable. Now, my lord, I go back to my old my lord practice. Kindly look at the paper book, my lord. Your lordship will find the London district judge, after service, kindly turns the paper book.
Yes, page.
My lord, page. The order sheet of the district delegate is not before lordship. The order sheet of the district judge is before lordship.
I was really wondering why it is not so.
Yes, this unfortunate, my lord, it's our fault. We have prepared the paper book.
Yes.
My lord, page, my lord, one on the paper book is not important. Kindly turn, my lord. To page 3. This is before the district judge. Petitioner files Hazira, LCR and original will have already been received. Requisite filed earlier. Issue the same at once. Fix for service return. Next date. Petitioner files Hazira. Service return received being duly served except the general notice. Therefore, the court, the district court, judge my lord was satisfied about service except general notice. Petitioner is directed to take fresh steps upon general public, none appears. Then, my lord, page 3 bottom, SR general notice received being duly served. Then, my lord, page 4 top, no appearance made by the OP. Appellant is directed to file draft copy of application in any Bengali newspaper widely circulated in the area where the near relatives of the petitioner are lastly resided or carrying on business. The draft copy should be approved by Sherestadar. Petitioner files Hazira along with draft copy of the publication, issue the same after approval by the Sherestadar. Valuation report received with the district delegate Katwa, let it be kept with the record. Petitioner filed one publication copy of Ajgal. None appears on behalf of OP. At this stage, the entire case record is received from the addition, which transferred to the court of the additional district judge, 5th Court, Bardwan, for disposal. Parties are directed to appear before the transfer court by the date fixed. Received the copy of the transfer from London district judge for disposal. Petition is absent. On several occasions, my client didn't appear. Matter was adjourned. Kindly turn, my lord, to order number 29th of January 2018. This is very important. On scrutiny of the record, bottom of page 7. On scrutiny of the record, I find that summons upon all the OPs, along with the general notice, has been duly served on 1/7/2016 and 14/11/2016 respectively. But till date, no written statement is filed by the OPs, and the statutory period for filing written statement has already been elapsed. In view of such circumstances, it appears to the court that the OPs are not interested to contest this case. I also find that none of the OPs have filed any vocalatama in this case till today, that the case do proceed ex parte against all the OPs. My lord, after recording such order and satisfaction of the district judge, there is no scope for arguing that the services were not duly made or that the citations were not duly made. The London judge will find finally disposing of the application, says that individually they were not served. The attention of the learned district judge was not invited to these orders. The earlier judge, he was an early predecessor in office, has recorded that the judgment and the citations are made, the services were effected, and then he declares the matter to be expert hearing. The successor judge, while disposing of the matter, does not consider these orders at all. And there is no reason why these facts should be ignored. And mine and friend is saying not served. It is recorded served. My lord, before the district delegate, a vocalism was filed by an advocate. So far, I have not heard anything that any step has been taken against that landed advocate. It's forged that there is a fraud practice about the court. And this is something, my lord, improbable. I will cause it to be served. I will cause it to be filed to my prejudice, to make an uncontested proceeding, convert an uncontested proceeding into contested one. Otherwise, my lord, the grant of probate would have been smooth. I mean, without any seamless grant, and I convert it to contested proceeding. I don't know, my lord, the filing of a Mokalasnama, whether it is the lodging of a caveat. Caveat is defined in the Succession Act. What is caveat and what is the filing of a Mokalasnama? The court, rightly or wrongly, treated it to be filing of a caveat and send it to the district judge. That's one aspect of the matter, but we are not concerned with that at this stage because they participated in the hearing before the district judge and the district judge disposed of. Now, my lord, is there any dispute before lordship that this is a hologram? Is there any dispute? Any party, my lord, appearing before lordship is disputing this is a holograph will?
This,
No. None is disputing that this is a holograph will written in the handwriting by my father. Nobody is disputing. If it is a holograph will, it has a value, a weight of its own. The Supreme Court. I don't.
no,
I'm-
Mr. Mitro is saying that it is a trial court who has disbelieved that it is a hologram.
No, could not, nowhere. Kindly turn the trial court. Nobody has said anything.
He says,
Disbelief.
no, trial court says that since there was a variance in ink, so it says that it is not in the
Doubt.
Yes,
Not
appears to me means he raises a doubt.
Kindly said because there's a variation in the ink,
Yes.
not variation in the handwriting. And he
Yes.
said there is some doubt. My learned friends are not saying this is not in the handwriting of the testator. Throughout. My learned friend Mr. Mitru was reading, my lord, the paragraphs of the will and saying he was not properly in proper state of mind to execute the will. Is there anybody saying that is not in the handwriting of the testator? And what is the reason for disbelieving Oyan Mukherjee, who is the advocate, that this is the handwriting of the testator? He signed in my presence, and I have signed in his. What is the reason for disbelieving Oyan Mukherjee?
Yes.
Kindly look at not that part of the judgment. That's at page 37. Kindly go over, my lord. Page 38. Page 38 of the paper book.
Yes.
In the middle, my lord, the 7 heirs of the testator have been set out. Then it is further contended that the said will in question was a holograph will executed with the testator nominee Mujumdar appointing his one son, Brojendra Mohan Majumdar, the present petitioner, as an executor of the will in respect of the scheduled property. Record goes to show that after general service of notice,
And also paper publication.
big lord,
And also paper publication.
service of, and also paper publication, no such person or legal heir relative as the OP entered his appearance to consider this case either before the transfer court of the London District Judge, Bardwan, or before the transferee court. Pertinent to mention that no notice was served individually. The predecessor in office has recorded his satisfaction served, declared the matter to be ex parte. He does not take note of it. Upon any legal heir related to the deceased testator. However, considering the non-appearance of the opposite party on the basis of general notice and paper publication from 29/1/2018, the case proceeded ex parte against the opposite parties. Now the court, the predecessor in office, has recorded that he is satisfied the service of the made. Down, Lord, kindly turn, Lord, to page 40. The petitioner, before that, the learned judge has referred to my deposition, the propounder's deposition, Brojendra's deposition. Kindly turn to page 40. Owen Mukherjee as an attested witness to the will in question, who as PW2, filing his affidavit in chief, identified his signature on the will in question as Exhibit 3C. And during his examination, the entire will has been marked as Exhibit 34. Although there is no contention either in the plaint of the petitioner or in the evidence of the said petitioner, Brojendra Mohan Majumdar, that his father, Dambani Mohan Majumdar, had written and executed the said will in question in presence of any attesting witness. But the PW2 in his evidence stated that the testator Navani Mohan Majumdar had written the said will in his own handwriting and put his signature in the said will in his presence and in presence of other witnesses, namely Tapan Kumar Chatterjee and Supriyo Chatterjee. He further stated that he put his signature in the said will in question in presence of Sri Navani Mohan Majumdar as per his instruction. Pertinent to mention here that beside the PW2, the petitioner did not try to prove the execution of the said will in question by examining the aforesaid two other attesting witnesses of the said will in question. Well, there is a section in the Evidence Act.
68. Section 68.
Yes, 68 and Evidence Act, Milord 78. One witness is sufficient to prove a document which is required to be attested. Now, my lord, the learned judge, there is no reason why, my lord, is requiring other attesting witnesses.
68 talks about-
Kindly look at below 78 also of the Evidence Act. 68 के बारे में section है.
Look at this, section 78 has no application because 68 is the important section of the Evidence Act. 78, I don't think so, because it talks about the proof of the official documents. It is not an
Yes.
official document.
No, this is not an official document, but what is required to be attested can be proved by the evidence of any attesting witness.
Yes, 68 is the 68 talks about at least one witness, attesting witness. If he comes, then what is proved is the due execution, nothing more than that.
That I have done, my lord. Owen Mukherjee has been examined. Owen Mukherjee is disinterested. Why the evidence of Owen Mukherjee is not being, believed. My lord, only one thing, my lord, I stop here. My lord, I have referred to a judgment of the Supreme Court, Your Lordship will kindly look at the judgment. 64th Supreme Court.
Yeah,
1964 Supreme Court. Page 529. I have referred to that, but I have read it out. I believe it, the copy is lying with your Lordship. Huh? Nothing. Your Lordship's officer will kindly turn to paragraph 5. This is the case of a holograph will. Before we consider the evidence as to attestation, there are certain preliminary facts which are not in dispute and which may be set out. The testator was a man of great wealth and a well-known lawyer of Calcutta. Though he retired from the bar in 1935, Milord, this is that Banerjee family, Milord, your Lordship, this is a famous family, Milord, of Hajas. The testator was a man of great wealth and a well-known lawyer of Calcutta. Though retired from the bar in 1935, he continued to be elected president of the Alipur Bar Association till the end of 1946. He died at the very advanced age of 97, when he was about 93 years old, when the will in dispute is said to have been executed. He was then head of a large family, having been sons, 5 daughters, and number of grandchildren. Ojoy Banerjee, Milord of Alipur Court, was his descendant. Your Lordship remembers Milord Ojoy Banerjee of Alipur Court was his descendant.
He also,
Beg your Lordship?
to the family also.
Yes, also. Okay. He continued to be elected president of the Alipur Bar Association till the end of 19. He died as a very old. He has then head of a large family, having 5 daughters and numerous grandchildren. His wife died in 1945. 2 of his sons, Sushil and Shonok, had preceded him. Before his death. The testator had already made provision for his heirs by executing a number of documents. The scheme he used was to a great extent prepare a perpetual lease of the property in favor of the person whom he wanted to believe. Ultimately, there is reversionary interest of the lease property which the testator had. I skip over it, my lord. Kindly turn, my lord. Kindly turn to page 287, last 10 lines of paragraph 5. Paragraph 5.
Actually, they have given us a copy of SCC, and which will never tally with the actual EIR. That is the whole.
Lord, Lord, the paragraph 5. AIR paragraph 5 begins.
I know. Which sentence you want to read so that we can find out from there.
Milord, paragraph 5 begins in
No,
AIR.
You are reading paragraph 6 in SCC. We are in tune with we are in tune with you. Tell us which sentence you want.
Milord, last part of paragraph 5, Milord, in AIR.
Correct. The sentence beginning with sentence which you want to.
I'm reading out the sentence, Milord.
Yes, please. Which line you wanted to read?
Milord, in my copy AIR, there is a head note. In paragraph 5, I read out the head note. The fact that the will in dispute is a holograph will.
Just 1 minute, we can find out the sentence.
I read out the fact that the will in dispute is a holograph will and admittedly in the hand of the testator. And in the last paragraph of the will, the testator had stated they had signed the will in the presence of the witness, and the witness has signed it in his presence and in the presence of each other. Rise a strong presumption of its regularity and of its being duly executed and attested. If there is hardly any suspicious circumstances attached to the will, it will require very little evidence. Has the Lordship got it, my Lord? Very little evidence to prove the due execution and attestation of the bill. Has the Lordship got it, my
Yes,
Lord?
sir, we got it, we got it.
But I'm on that if it is a holograph will, and if there is no such suspicion, very little evidence. Therefore, in my case, it is a holograph will and an ex parte hearing. My client were advised to file, my Lord, only the will and the evidence of the one attesting witness and of the propounder. The learned judge wanted more evidence. It's a holograph will, propounder and, my Lord, the attesting witness has deposed. They have deposed with the court. The court doesn't, my Lord, doesn't proceed on that basis. In the case of a holograph will, and particularly when the matter is going ex parte,
Yes.
did not bribe. I go back to page 41. I think that passage has been page 41. Pertinent to mention here that besides the PW2, the petitioner did not try to prove the execution of the said will in question by examining the aforesaid two other attesting witnesses of the will in question. Ex parte hearing, holograph will, Supreme Court says very little evidence is required to prove the execution and attestation. I don't know, my Lord, I have no experience of practicing the original side. In the original side, my Lord, a will, my Lord, with the consent or with the consent of the parties is never required to be dealt with as court, my Lord, as a regular hearing matter. This is given, my Lord, as a matter of course. Your Lordship might have dealt with such cases. I mean, probate matter with consent, my Lord, can never put with the court.
This is what the officer said to says. Yesterday I just reminded of Mr. Mitro also that though there is a rule that it is not really printed in the causes, never comes, it comes in the chambers and then the signature is done. But when I was taking an interrogatory matter, I made it sure that at least the propounder should come before me. He must prove it. So I started that particular practice and I never signed a single, the probate or that without examining the propounder, without examining the testimony.
Previously, my Lord, Mr. Mitro will be able to assist your Lordship. Previously, my Lord, if there is a consent, my Lord, you have never dealt with the court as a hearing matter.
Previously means before I was given a determination of interrogatory, it was not done. Even thereafter, I believe it is not done.
All matters to which are coming before the court. Okay. So really they have called up, we have to appear and it's formal. Little bit.
Problem is, my lord appeared more in the appellate side, so the the mindset was more appellate side than original side.
No, it is not a mindset, sir. It is what is a probate court, is a court of conscience. Is a learned judge has to clear all the doubts, and his conscience must be satisfied. Otherwise, he will not, should not.
Now, my Lord, I beg to proceed, my lord.
Yes,
Therefore, the learned judge is commenting upon non-examination of other attesting witness. My respectful submission is he should have taken into consideration the fact this is going ex parte. This is a holograph case of a holograph will, and the Supreme Court is pointing out very little evidence to prove the execution and attestation. There is no complaint about Ayan Mukherjee that he will depose Milord without without any basis. Milord, he was present throughout. He attested. Attested. The court is not believing him. Now, Milord, kindly turn page 41 bottom. After careful perusal of the record and the will of the Trisha Navani Mojumdar in question, it appears that although there are total 8 pages, another strange finding. All the pages are not signed.
Yes.
Kindly turn to section 63, my lord, of the Succession Act. It doesn't require, my lord, all the pages to be signed.
Yes. Yes.
I think your lordships are rising now, my lord, for the recess.
How much time will you take?
Another hour and a half.
Oh. I just thought that we can skip over the recess if you can complete it within 15, 20 minutes.
My
So
lord,
we-
I will take.
It's going to be.
I beg to have more time, an hour and a half.
So what do you propose? Would you like to continue or would you like to?
Whatever is convenient to your lordship.
It is all up to you because we have already substantially heard you are there in reply. You are just giving what Mr. Mitro has actually argued. So I think it is better to continue and finish.
I will continue after recess.
Yes, please. Then we'll finish.
can they do?
Please. Thank you.
যেটা আমি একটা একটা টেস্ট করে তারপর চলে আসবো।
কি?
একটা কোভিড এর টেস্ট হচ্ছে আমার,
Oh,
ওটা করে তারপর চলে আসবো।
আর অন্যের কোন পয়েন্টে বিশেষ ডিল করা দরকার?
যেটু ও বাইরে সবাই, আমি ফোন করছি তোমাকে, ফোন করছি, ওটা সবাই ওখানে, আমি তোমাকে ফোন করছি।
অল্পে খাওয়ার বাবুকে নিয়ে যাবো। গেছে 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 তুই বাবুকে নিয়ে যা, বাবুকে নিয়ে যা। এই বাপ করছে। হ্যাঁ হ্যাঁ তুমি ও টিভি এটা তো হুম হুম হ্যাঁ মিউট করছি ধর।
Being better.
Mukherjee, unmute your system. Yes. Yes.
I'm sorry, my lord. It was unmuted. So before the recess, I was placing before lordship the judgment of the landed district judge. The landed district judge, my lord, held against me first on the ground that all the pages are not signed. Second, on the ground that only one attesting witness has been examined. Third, on the ground, there is a change in ink in the writing of that bill. Fourth, on the ground, the custody has not been explained. Now, my lord, so far as the first two grounds I have made my submission, the third ground is a change in ink. The landed district judge is not holding, the handwriting has changed. The ink has changed. The usual presumption will be that there was a shortage of ink and therefore he had to change the ink. Otherwise, handwriting is the same handwriting is not disputed. And the fourth,
He has observed that it is not a same handwriting.
beg your lordship,
He has observed that it is not a same handwriting. That is, if you come to page 42 of the paper book.
page, my lord, 42.
The first paragraph, beginning with the first two pages of the said
The
bill.
first two pages of the said will in question and remaining 6 pages are written in different inks. Inks are different, not just handwriting is different.
Later on he observed.
And appears to be not in the same handwriting. Although
What he says is not in the same handwriting. Now there are two things. What you have to say that this other thing which are written in a different ink is not in the same handwriting, or the entire document is not in the same handwriting, or what? I do not know what you really want to say.
my lord, after the handwriting ink has changed, the landed the testator has also signed it. Testator has also signed it. Kindly look at the document, my lord, the will.
We have seen that.
Therefore, he is accepting it, his own handwriting. After the ink has changed, the testator has signed it.
Yes.
And my lord, Ion has said the entire thing was handwritten in his presence.
But there is one word which is used. Mr. Mitro has taken an exception to this. If you come to page 29, that is an evidence of the propounder. He is very critical on this. The second paragraph. My father,
Since
such
this
and
is
such, had executed one will prior to his death, bequeathing all his properties, all through that will. Then the second, the will was scribed by a testator himself. This is what he really wanted to say, that there are two concepts. Scribe, one is a scriber of the will and one is the executant of the will. And in holograph, it is not a scribe, it is something which is written by himself.
my lord, in substance, it is in substance and the statement that is a holograph will. It was written by him. It was the language, the attesting.
The will
This is-
was scribed by the testator himself and it was a holograph will. So he is critical on the
this is
word
a-
scribe.
my lord, it means, my lord, it was written by him. And this scribe expression, scribe was possibly used with the court translating the evidence. It was not there, my lord, in his deposition. The deponent didn't use the expression scribe. possibly was a learned judge who has recorded the deposition as described. What does it mean? What else does it mean? Testator scribed himself. And next sentence, it was a holograph will.
Yes,
I think again, holograph will is the entire will, my lord, written by him.
yes. Yes, so according to you, this scribe word has been loosely used by the judge recording or translating the evidence,
Obvious,
and the sentence has to be read in
as a whole.
in its entirety, so that to get the real intention is holographic.
Holograph will. And that is also the deposition of the attesting witness.
Yes.
Holograph will.
Yes.
And my lord, the custody has been explained. It was in the custody of the testator himself. The will was in all the wills, my lord, were in the custody of the will. The eldest sister has filed an application and she has said the will was in the custody of the father.
Correct.
And only after the demise of the father, all the wills were discovered.
Yes.
And my lord, I have one submission regarding service of the summons and citation. He has accepted the dismissal of the probate application with the learned district judge. He should not go back. He has accepted the order of the district judge. Non-service had happened before the order of the district judge. He has accepted the dismissal of the application in spite of non-service. Now, my lord, after we face an appeal, he goes back. Now, the non-service is a question to be decided here on an application for revocation of the bill. Under 263, this is usually a ground. 263, my lord,
No, I know.
non-citation.
This is non-citation is one of the ground for revocation of will. Probate, sorry, not will, sorry. Probate.
Sorry.
So it is revocation of probate is a ground. They can go for revocation. There is no debate. Now the situation is when the appeal has come and if the appellate court is testing the order of the trial court, means the probate court, first court of first instance. Now in that event, if this point of non-service is taken, then the court, what is your opinion on this? What is your submission on this? That will the appellate court go into those aspects, or will not the court go into that aspect? Appellate court. I'm just talking
My lord,
about.
after acceptance of the order of the learned district judge dismissing the probate application, they have ignored the issue of non-service. They have clearly said, I accept the judgment of the learned district judge. The learned district judge has dismissed.
Now he is really banking upon an order 41 rule 22 also. He is saying that though I am not aggrieved by an ultimate decision, rather I support the ultimate decisions, but I am really aggrieved by certain portions, the observations of the trial court in
No,
holding.
there is no observation in the trial court judgment. About service, there is an observation. In the trial court judgment, there is an observation that individually not served.
Correct.
That is not correct. Individually served, that is no part of the judgment.
So what he wanted to say that if the court has come to a finding that individually it was not served, the court should have stopped there and should not have progressed or proceed any further unless the service is affected.
But may I just request Mr. Mukherjee to see page 7 of the paper book.
I have
Order
read out.
I have seen that order. I have seen. This is what
I have read out.
Mr. Chatterjee, I am just recapitulating what Mr. Mitro has argued, so that Mr. Mukherjee is in reply, he must respond to those arguments. That is what I really wanted. I just inviting his attention on that.
I appreciate you, Lord, but I have read out page 7.
Yes,
Page 7.
that this finding is wrong.
finding is to be apparently wrong because
Suppose-
he does not consider the satisfaction of the court.
Mr.
And
Mr.
individually served.
Mr. Mukherjee, suppose the appellate court, after looking into the record, is not satisfied about the service. And then also not satisfied about page 7, where the declaration as to the service was made by the court.
Okay. This
So
is at least
What the appellate court is supposed to do? Will ignore it, go by the ipse dixit of those declaration, or the appellate court can?
that may be a ground in the revocation application, not before the appellate.
Not the appellate.
My lord, may I cite one judgment, my lord? May I
Yes,
cite one judgment, my lord? Funny
yes,
judgment, but it's a judgment of a very powerful bench of this High Court. A judgment of Chief Justice Chakraborty and Justice Lahiri. Two senior most judgments of the Calcutta High Court at that point.
yes.
What happened in that case, a 56 Calcutta law.
Yes,
What
yes. We have that 56, page 650,
Page, my lord?
650.
No.
No, it's not that.
56
Yeah,
Calcutta.
56 Calcutta, not
Yes.
56 CWN.
56 Calcutta, my lord, I'm giving you a lot.
Yes, yes,
537.
yes, yes, yes,
Is it before your lordship?
yes. Paragraph?
My lord, kindly turn to head. Is it AIR before your lordship?
Oh,
AIR
no, that is a whole problem. Nowadays, everybody is going for an SCC online, and where the paragraph will not tally with the AIR.
Paragraph 20 of the AIR.
This paragraph begins with
I'm just reading out to Lord. As I said at the beginning, that there is some danger in returning
19 here.
19. That's paragraph 20.
Yes. There is some danger in returning a negative answer to the question.
It's a judgment of Chief Justice Chakraborty.
Yes.
As I said at the beginning, there is some danger in returning a negative answer. The question as framed because the real question which arose out of the assess's contention and which required consideration was never considered by the tribunal, and therefore, if the matter goes no further, then the contention will not have been properly disposed of. We can, however, protect the interests of the assessee only by qualifying our answer and indicating
Indicating the precise point to
Precise
which
point.
is it limited.
to which it is limited.
Yes.
What we do decide is only this, that the tribunal was not justified in holding that service of the notice was not sufficient service with the meaning of section 63 Income Tax Act merely on the finding that the notice had been served upon a brother of the assessee and who had no authority to receive it on the assessor's behalf without considering the presumption. The presumption, that was the registered notice required to serve. There was a presumption under section 27. I'm posing this question for myself, Lord. Is there also a presumption under section 14 when the notice is sent by the Nazir of the court and he was performing an official duty, reporting that it has been duly served upon the party, though it has been actually served upon a brother, not upon all the brothers. There is that presumption, my Lord, under section 114. Brother has received it, residing in the same house. The other brother is admitting that 6 respondents, 4 and 5 are residing in the same premises. I'm trying to derive inspiration from this judgment of the High Court. There, section 27 was there. In this case, is 114 available, and that presumption that if a brother is served, it will be presumed the other brother has also been served. This usually happens, my lord. When a notice is served upon a lady, the husband or some other person in the family receives it. The presumption it has been duly served.
No, that is there under the code of civil procedure also, that the service upon any adult member in the
That's order,
or
Rule
who is
15.
duly authorized to receive it, that is always regarded as a due service.
That's Rule 15.
Yes, there is no difficulty. There is no difficulty. Order 5, Rule 15 or 16,
15.
15. So this is already there. We are conscious. Here, the situation has become somehow, may I use the term dicey, because everybody has come and wanted to disclose their stand, which they did not in the trial court, because this is an appeal arising from an ex parte judgment.
Yes.
It is really coming up. Several evidences are coming up. The new evidence which is not there. So whether the
None
appellate
is,
should go into
none,
this aspect or not.
my lord, new evidence is coming up, my lord, to the effect that my will is genuine. New evidence does not destroy my will. Will your lordship consider, my lord, my land furniture withdraw as referring to the deed of gift? I have produced the deed of gift. I have also produced the 3 other wills executed with the same testator on the same date with the same attesting witnesses. Your lordship will not take them into consideration.
He is
Same
talking
date.
about adim, the provision relating to adim.
Beg your lordship's pardon.
He is talking about the provision relating to adim. Adim.
Yes. The adim will take place with that. The executing court is not concerned with that. The executing court is only concerned with the execution and attestation. They will not go into that question. If it is adim, it is adim. That will be decided in other proceedings. In this proceeding, the court is merely concerned with the execution and attestation.
He is talking about section 152, I believe.
151 or 152. Either 151 or 152, but
152.
152. It will add him.
It
That
says
will not be decided. That will not be decided with executing by probate court.
this is the chapter. The chapter is the head note of the chapter is of redemption of legacies.
Yes.
And the section says that if anything which has been specifically bequeathed does not belong to the testator at the time of his death, or has been converted into a property of a different kind, the legacy is deemed. Legacy is deemed. That is, if cannot take effect by reason of the subject matter having been withdrawn from the operation of the will.
Is this a matter to be considered at the time of grant of probate? It's a matter to be legacy becomes a legacy after the grant of probate.
Probate.
It
So,
does not.
and the legacies and the assent to the legacy is also one of the important factor.
Yes.
Unless the assent is given, the legacy does not become perfect.
Mature.
So it is only at the time when the assent by the executor is made.
Post probate consideration, not at the time of grant of probate.
And the illustration which is given to this section is also very apt.
Yes.
A bequeath to B the diamond ring presented to me by C, my gold chain, a certain bale of wool, a certain piece of cloth, all my household goods which shall be in or about my dwelling house in M Street in Calcutta and at the time of my death. A in his lifetime sells or gives away the ring, converts the chain into cup, converts the wool into cloth, makes the cloth into garment, takes another house in which he removes all his goods. Each of these legacies is deemed.
Does it render the will void
No.
or post?
That's my tentative the opinion.
Lord, kindly read it. There is no question of a tentative opinion. Kindly take a firm opinion. It's a post probate consideration.
Yes. Yes,
Now, my lord, I am on another aspect. Kindly take into consideration order 41-27.
yes,
My application indicates that on the same date, same testator, with common attesting witnesses, executed 4 wills. My will is one of them. My landlord is very keen to oppose the application for additional evidence. What is this additional evidence? 4 wills, are you denying them? No. Rajendra has even applied for probate in respect of one of the bills. Monindra, my lord, in your lordship's presence, my lord said there is a bill in his favor. He's enjoying the restora and possession. They appropriating the profits. And in my case, my lord, he was a lunatic, a man of unsound mind. This is being argued. He's enjoying his legacy, my lord, exclusively.
what he says is that on that he never used the term lunatic or
My unsound mind.
yes, unsound mind. Why he says is because of the observation of the judge, because of the evidence which has been adduced by the propounder at page 29. He says that he simply said at page 29 that I'm
No,
reading.
he was reading the. He
reading
was
for-
reading the.
I'm reading for you. My father at the time of examination of will was physically fit and mentally alert and was in a sound and disposing state of mind. He says that mere saying the same does not absolve you of a further responsibility or onus to prove that he was a mentally sound and mentally alert physically.
My lord, I again fall back upon that Supreme Court judgment, 1964 Supreme Court. Holograph will each sentence reflects his mental ability. Holograph will each sentence.
Yes.
I'll read the Supreme Court judgment.
Yes, and then he says that if you look at the will, the language which is used does not appear that the person was of a sound mind.
Will your lordship kindly casually have a look at his own will? Mr. Mitra's client's own same paragraph.
He is disowning his own will. He is
No. Kindly ask him to disown it. He has not disowned his will.
He is not.
He's
He has
disownning his.
for probate.
Beg your lordship, man.
He has not applied for probate.
He's enjoying the property without the probate, exclusively enjoying the profit that is admitted before lordship. Let
No,
him
it's
disown
not.
the will.
He has not said so anywhere.
Before your lordship, he has said, Kamalesh Bhattacharya has admitted, Kamalesh Bhattacharya has admitted before in your lordship's court.
Mr. Mitro's client, so far as he is concerned, he has not said so. Rather, he is not really denying nor is accepting anything of such kind.
Yes.
Wanted to say that look at the language which is used in the will, which shows that if the person cannot, because the language is, as he is very, I would say, particular about this expression that
I have heard him.
out of my wedlock, he has said that how can a grandson or a granddaughter or a wife of a
Language is
son
inappropriate.
can be.
Language is inappropriate. My
Yes.
Lord Rajendra has applied for probate. In Rajendra's will, same thing has been said. Kindly look at
What do
Rajendra's.
you have to say about Section 72 of the Indian Succession Act?
Yes, my lord. No, section 72. Section 72.
No, not 72, sorry, 74.
I just, my lord, I will look at it. My God. May I read out for Lordship's convenience? It is not necessary that any technical.
You read and then react.
It is not. Now, my lord, is there any doubt, therefore, what was the intention of the testator? Exclusively given to the son to be enjoyed by himself with his wife, son, grandson. Intention is very clear. Technical words will not that to be ignored. In that paragraph, is there any doubt that he wanted to convey an absolute estate to be enjoyed by him with his son and grandson? Language will not used is inappropriate, but does it affect the operation of the will or the intention of the testator expressed in the will? Kindly read it once more. It is not necessary that any technical word or terms of art be used in a will, but only that the words be such that the intention of the testator can be known therefrom. Is there any doubt about the intention of the testator?
No, I wanted a reaction from you on this.
That is an effective answer to Mr. Meter.
Acha, is it necessary that while granting a probate, the content has to be gone into, content of the will has to be gone into?
No. The will is only certified the will. This is the will. All post probate considerations.
Yes.
Now, my lord, I press my application for additional evidence. I rely upon a judgment of the Supreme Court as a constitution bench judgment. If for the ends of justice it is required, the court will take them into consideration. Your lordship is presiding over a court of conscience. Your lordship is presiding over a proceeding which will operate as a as a judgment in rein. A dead man's property, the disposal of a dead man's property is under consideration. The dead man can't come and assist your lordship by making his deposition. If he has executed something which is beyond dispute, and if the execution of that document is not under challenge, your lordship will take them into consideration in this case also. My lord, I'm referring your lordship, my lord, 1963 Supreme Court Constitution bench judgment. 1526. My lord, kindly have a look at it. Paragraph 16. Again, may not be AIR.
Obviously, they do not subscribe. How the paragraph begins?
Under Rule 27.1.
Just 1 minute.
In my AIR, paragraph 16 in AIR copy.
No. Under rule
27.1. Near about para 16.
No, I'm just 1 minute. We are reaching to that.
Sixteen and 17 in AIR.
No, the paragraph is beginning with under the rules 27.
Yes, 27.1. The appellate court has the power to adhere.
No, it is which one you are reading?
AIR 1963 Supreme Court 1526.
Correct.
Parties are
K. Venkataramaiah versus
Venkatarama. Yes. Constitution bench judgment. At the middle of the judgment, paragraph 16. Under Rule 27(1), the appellate court.
No, we are not getting it. Actually, we are not getting it. Any paragraph before that? Can you read any paragraph before that?
Yes.
Under Rule 27. Yeah, that is the
The object of Rule 27(2) clearly is to keep a clear record of what have.
the
27,
object of
Rule 27(2). That's paragraph 13. Mr. Chatterjee,
we are unable to find out.
We are trying to get a book from the library.
The what library book?
Sir, this is
Any other paragraph prior thereto?
such requirement of the court is not likely to arise.
That is another paragraph.
Para 16, 17.
No.
After the middle, my lord, it must be after the middle under Rule 27(1).
No. Don't say. Please tell us the beginning words of any paragraph. Otherwise, we will not be able to find out.
Just a second, my lord.
Beginning word of any paragraph. Start with paragraph 12. What it says. So we can correlate immediately.
some
What it says, paragraph 10 of that AIR, how it begins?
In view of what the High Court has stated in this passage,
So the passage might have been quoted.
in view of what the High Court has stated in this passage, it is not possible to any.
No, just the High Court, this passage might have been quoted.
Paragraph 16 in my AIR.
No, this passage,
Para 16. In online para 16.
Mr. Chatterjee, kindly see your WhatsApp. I've sent it to you.
paragraph 16. Yes, in view of what High Court has stated in the passage.
In view of what High Court has stated in this passage.
We got it. It is not possible to say that
the High Court made the order for admission of additional evidence without applying its mind. It seems clear that the High Court thought on a consideration of the evidence in the light of the argument that has been addressed already before it, that it assists them to arrive at the truth on the question of Reddy's age if the entries in the admission register of the school were made available. It was vehemently urged by the London Council with the parent that there was no such volume of evidence of the High Court that it could not be seriously suggested that the court required additional evidence to enable it to provide with judgment. The requirement is to be remembered was the requirement of the High Court, and it would not be right for us to examine the evidence to find out whether we would have required such additional evidence to enable us to pronounce judgment. Apart from this, it is well settled. It is well to remember that the appellate court has the power to allow additional evidence, not only if it requires such evidence to enable it to pronounce judgment, but also for any other substantial cause. There may well be cases that even though the court finds it that it is able to pronounce judgment on the state of record as it is, and so it cannot strictly say the requirement of additional evidence to enable it to pronounce judgment. It still considers that the interest of justice, something which remains obscure, should be filled up so that it can pronounce its judgment in a more satisfactory manner.
Yes.
Such a case will be one for allow additional evidence for any other substantial cause. Now, in this case, my lord, the four wills were executed on the same date, same person, substantially same attesting witnesses, disposing of the different parts of his property. The testator had a scheme of disposition, and my client's will fits into it. Kindly remember this is the judgment in rem and is a court of conscience. They are opposing the additional evidence on the ground, my lord, and not required by the court.
Yes.
This is a constitutional main judgment, my lord. I am not aware of any judgment, my lord, questioning the propriety of the judgment. What is this additional evidence? My friend Mr. Mitra was relying to the deed of gift. That is also in an application for additional evidence filed by me. Additional evidence will show that on the same date, testator was executing 4 wills. All holograph wills. Language is almost same. Kind of find the same paragraph that Mitra was reading out in his own will. In the will of Jitendra, who has filed an application for probate, same paragraph. Jitendra was not questioning the law, the mental balance of his own testator.
Yes.
Therefore, my lord, the other 2 judgments, my lord, I had in mind. One is a Privy Council judgment of 58 in an appeal. Page, my lord, 254. 254, famous case. Parsottim versus Lalmore.
Hmm.
Your lordship possibly remembers, my lord, your lordship might have the pleasure to consider this judgment on many occasions. This is on additional evidence. When additional evidence is to be considered, after going to the entire matter, I read out. Mr. Chatterjee, is it AIR or 58 Indian appeals? I don't know, my lord.
Indian appeal.
Indian appeal.
Yes.
Mr. Prasad has got a copy of Indian appeal, my lord.
Yes.
Grateful, lord. Kindly turn the head note.
Whose book is this?
Mr. Chatterjee's book. Mr. Chatterjee's book.
May I read out the head note?
Yes. Yes, Mr. Book.
By the term, only the head note. By the terms of Order 41, Rule 27B, it is only where an appellate court requires that it finds it needful that the additional evidence can be admitted. It may be required to enable the court to pronounce judgment or for any other substantial cause, but it must be the court that requires it. The power cannot be exercised on an application by a party before the appeal is heard. I was placing this application after all the facts in the appeal involved are before your lordship. Your lordship can decide the desirability of admitting this evidence in the facts of the case. Then, my lord, the power cannot be exercised on an application by a party before the appeal is heard. Wherever the court admits additional evidence, it is bound by Rule 27 to record the reasons, and by Rule 29 must specify the point on which the evidence is to be confined. The power should be exercised very apparent. Why I am citing this judgment? I wanted to place this judgment after the entire facts of the case are placed before lordship. Sentence after the appeal is heard.
Hmm.
My lord, there's a Supreme Court judgment to say on the same point. In 1951 Supreme Court,
Page 1 or page 193?
one-
Page 1 or page 193?
193.
193.
I don't know why I lost is asking this question to me.
You referred 51 Supreme Court, so that's why I say page 1 or page 193.
193, my lord.
Yes.
Same point, same finding.
There is a risk which we always were taught not to give the book, because sometimes in the margin of the book there are many judgments which are recorded saying distinguished, referred, and then sometimes overruled.
I had those notices also in my book, my lord, but now after the recent publication of digest, my lord, it's not necessary. And at present, the mobile, my lord, internet, it's everything.
So it is not that we notice this two judgments are there in the margin.
That is in that book, maybe of Justice Purushottam Chatterjee, I don't know.
So that's why
Yeah,
page 1 or page 193.
193.
Yes.
Tobin Chatterjee, not Purushottam Chatterjee.
That may not be the acquisition of Mr. Aniruddha Chatterjee, maybe the book of Justice Purushottam Chatterjee.
Yes.
But therefore, I am pressing this. Your Lord has seen that
51 এটা কোথায় বলছে? 93 দিতে বলছে।
দিয়ে দাও, বইটা দিয়ে দাও।
নামটা কি? অর্জুন সিং তো।
Tiny time, Lord, if your Lordship has got the 51 Supreme Court, page 193, head note B.
No, not
We don't have a head note. These are
Sorry.
all see, so you will not get a head note. That is a copyright. Infringement of a copyright. Hmm.
পেজটাও মিলছে না।
Highly charged, my Lord. Paragraph 7. It is strenuously argued with the London Council of the Appellant.
This is paragraph 11 here. Yes. It was strenuously argued by the
Argued with the London Council of the Appellant that it was not open to the High Court to interfere with the discretion exercised by the district judge in allowing additional evidence to be adduced, and that even assuming that there was an erroneous finding of fact, it must stand as the second appeal can be entertained only on specific grounds. There is, however, a fallacy underlying this argument. The discretion to receive an additional evidence is not an arbitrary one, but a judicial one, circumscribed with the limitations specified in Rule 41, Order 41, Rule 27. If the additional evidence was allowed to be adduced contrary to the principles governing the reception of such evidence, it would be a case of improper exercise of discretion, and the additional evidence so brought on the record will have to be ignored, and the case decided as it not. Under Order 47, Rule 27, it is the appellate court that may require the evidence to enable it to pronounce judgment. As laid down by the Privy Council in the case of Keswaji versus IP Railway 34 Indian Appeal, the legitimate occasion, the application of the present rule is when, on examining the evidence as it stands, some inherent lacuna or defect becomes apparent, and not where the discovery is made outside the court of such fresh evidence, and the application is made very important. And they reiterate this view in stronger terms, even in the case of Parsottam versus Lal Mohan. The true test, therefore, is whether the appellate court is able to pronounce judgment on the material before it without taking into consideration the addition. Now, this stands modified, my lord, by 1963 Supreme Court Constitution. And for the ends of justice, if the court finds for the ends of justice is required to be taken into consideration, court should do it. And in a case of judgment in rem, in a case with the court, but the case with the court is a court of conscience, and dead person's property is in dispute, court will will have the evidence before it. All the relevant evidence. Your lordship will not treat it as an ordinary adversarial litigation. Here the caveator is not an adversary. The caveator has to come to court to be a witness to the proceeding and not as an opposite party, not as a defendant. The caveator is not an opposite but a defendant in the usual sense. They have come to witness the proceeding, and this will assist the court. Four holograph wills on the same date with the same testator and almost with the same attesting witnesses. Lack of balance of mind, lack of proper attestation, proper execution will be evident from the four wills. And kindly remember, this is a court of conscience in a probate case where the original testator is not there to place his case. There's no dispute. These are all admitted documents. Let when Hon'ble says disown it, I'll welcome it. I'll go and file an application for partition.
Yes.
Jitendra has admitted this will, has filed an application for probate. Kindly turn to page 74 of the paper book. 74 now. Jitendra application. Notice term. I'm sorry, I'm giving you a lot to the page.
Page 84.
84.
This is their first time here.
Hmm.
Without any additional evidence, this has come.
Which one belongs?
It is a part of an order 41 to 27 application.
Yes, part of the order.
It starts from 71.
21 part of that.
So the annexure B. 70, page 70.
Same will. Only the name of the legatee is changed.
No, the prayer portion is only in relation to these three wills. It does not talk about this particular notice that one of the party has applied for probate.
Oh yes, it is stated there below. This is being thought to be adduced as a piece of additional evidence.
No, if you come
Page
to page 81,
Page
Mr. Mukherjee, if you come to page 81, that is the prayer portion.
And the letter dated. And the letter dated.
This is not a letter, this is a notice.
But para 9.
Describing, this is described as a letter below.
How can it be a letter?
It is a notice.
It's a notice.
But in
111. This is not a 111.
Page 77, paragraph 9.
Yes. Yes. It is referred there.
No, you are talking about actually the wrong dates have been given. You are talking about the letter dated 1/11/2013. Please come to page 86. Actually, it is a 4/11/2013. This is a letter. And then you talk about the letter dated 21/3/2016. You come to earlier page. No, this 2016 is a wrong. It should be the earlier page 85, 25/11/2013. These are the two letters you are relying upon, but so far as this is concerned, is nothing stated. And then you say the partnership deed.
Will ask you kindly turn to page 77.
Yes. Where annexure B has been given, but you do not want to produce it as, because it does not say. Said notice is marked as an exhibit. And you have wrongly included this as an exhibit. It was not there. It's not really there. Oh, sorry, notice. But I do not find. The date is conspicuously absent. It can't be. Page 77, I have seen that. He's applied for probate, he has given. And then say that the copy of the said notice is marked as letter B. But the prayer portion does not tally with that. The prayer portion, he is talking about only the three wills.
Letters.
The partnership deed.
I think the date is missing in this document, my lord. If my lord sees, just have a look at it. Date is not perhaps missing.
Nothing. Your prayer, you do not want. Your prayer is very defective.
My lord, when it is a part of the application for additional evidence, kindly permit us to amend the prayer in the additional evidence application. It's clear.
Actually, it should be a notice because there is no date. That should have been the place. But that reference 2016 he's talking about, but here, if you know, page 85, letter. This is really talking about the letter. Correct. Why I said 16? Because the next page, if you come, it is a 4/11/2013, and the prayer is talking about 1/11/2013.
No, there is a mistake.
In the prayer, we wanted 1/11/2000, but it is actually 4/11. That's why I just say that it talks about 21/3/2016. Oh, this is in November. This is 23. Which one is it? 87. This. Yes, 21. This must be the what they wanted. No, Mr. Mukherjee, the prayer does not tally because if you come
Yes,
to
sir. It's not a prayer. Body of the petition mentions it. Body of the petition.
But you do not want to produce it as additional evidence.
My lord, I am now making a prayer, my lord. I am making a prayer. The prayer has not yet been dealt with.
A party may disclose several documents, but he can rely upon some of them as a evidence.
My lord, does it appear so, my lord, in the body of the petition that I am only applying for additional evidence in this for others? Then I would not mention this one. In paragraph 9 at page 77, I am dealing with it with a view to getting it. Plus, people are annexing it.
Not disputed.
Who has drafted?
Ultimate responsibility is mine.
No, that I know, but you are a modest person. You are taking a responsibility, but you have not seen the birth of this application before you are engaged. Who has drafted?
I will take responsibility for this. It's not Mr. Mukherjee.
I want who has drafted it. Responsibility everybody is taking, but I am asking who has drafted it.
Take it for instance, my lord, I have done.
Yes.
My lord, I have mentioned it in paragraph 9, my lord, in the prayer portion omission. Let us state that. And this is, this has been,
Anyhow, yes. You
therefore,
can,
that there are 4 wills. I've applied for probate in respect of one. The other person is Jitendra, he has applied for probate. I am not sure Mr. Mitro is disputing or disowning the will in well. He's only enjoying the property for since 2014. Let him say so that he's not enjoying the property, appropriating the entire property. It's a hotel. It's a restaurant, largest in Asansol.
yes.
And the other one is the legatee in respect of a floor of a building occupied by a nationalized bank, enjoying it. That I have said in this petition for application of additional evidence.
Now, suppose, Mr. Mukherjee, we let us see. We have not taken up a final decision or conclusive decision on this. What we are thinking is, suppose if we accept your application of for production of the additional evidence, then in that event, will it not be proper that the parties must be given an opportunity to produce by way of tendering this document through a proper means as recognized under the rule of evidence? Those have to be, because these are all photocopies, and therefore one has to come and then prove it as an additional evidence.
If your lordship permits that, we will file the original here before lordship.
No, I'm just asking you that will it
My
not?
lord, it all depends
to be
upon the
proved.
facts.
It
If
has to
oral evidence, if oral evidence is, if oral,
is required, because
oral
the
evidence,
author of the judgment is no longer there. Author of the document is no longer there.
yes.
Author is not here. Then
But
it
if
has,
it is admitted, my lord, it will be taken into evidence.
they are
Let them
not.
file.
That's the whole problem, because they have not admitted as yet.
Jitendra has admitted it.
No,
Jitendra has filed it.
one will do, but what about the rest too?
Rest too, my lord, if they are disputing it, it's all right. Kind leave it aside, leave them aside. Let them dispute their wills in their favor.
But one party has they I do not know, because they might get an opportunity, or they may have gone there and filed a caveat, raising an objection to a grant of probate.
Let them say so, my lord.
Whatever
Let them
it-
say so.
So
They have
this-
fine opportunity. They have,
all under presumption, we are really proceeding on that basis.
my lord, they have not.
Might not. Everything is possible.
My lord, let them dispute their own will first. Let them dispute their own will. Let them file an affidavit. This application.
I'm just talking about the case of additional evidence. This is what I was just thinking aloud.
Yeah, it reminds the Order 41, Rule 27, Sub Rule 2. The
No,
appellate court can.
I know. Then evidence, somebody has to take it.
Without remand.
Appellate court itself, or will remit it for a limited purpose to the trial court, only to take an evidence and return, or the entire matter should be sent back so that
My lord,
we
I
decide
was
to send
submitting,
back. These are the three options open to the court.
I was submitting before lordship. It all depends upon the stand taken by the concerned respondents. If they dispute it, your lordship will go into that question. If they don't dispute it, your lordship will take them into consideration. Are they disputing their will?
Yes.
Order 41, Rule 27 2 allows the appellate court to do that.
No, I know. I'm saying that there are three courses open in this regard. The appellate court itself can take an evidence. There is no difficulty. Or appellate court can exercise its discretion in sending this particular to the trial court for the purpose of only taking evidence by the parties and exhibiting the documents, and then return to the appellate court. And the third one is that the appellate court may set aside the order and complete remand, permitting the parties to amend and then lead an evidence and then incorporate. These are the three options open. Now it is a choice of the appellate court what it will do.
My lord, the appellate court will exercise its choice after ascertaining the stand of the respondents concerned. If the respondents admit it, my lord, there is no question of sending it back. Your lordship will consider them here and now. If the respondents dispute it, your lordship can consider the question of limited remand.
Yes.
If the respondents are disputing it, only then. Jitendra is not disputing, has not come to oppose my appeal itself. He's not opposing my appeal.
Not before us. The problem is the Jitendra is not represented. He's not there before us.
At least he's not appearing.
That is what I'm saying. He's not before us.
Your Lordship can ascertain the views of the concerned respondents.
Why the court will take an evidence in this regard? Because they might have taken a stand, whatever they want to take a stand that. Anyhow, yes.
My Lord, I have relied. Is it necessary for ends of justice?
Yes.
Your Lordship is dealing with the property of a deceased. Your Lordship is delivering a judgment, will be a judgment in rem. Your Lordship is a court of conscience. Will your Lordship take kind care to see that the property of a deceased is properly disposed of, not
Yes.
grabbed by grabbers?
Yes. And they
Understand?
anything more on Order 41, Rule 27?
My Lord, order, no, nothing more. My Lord, the two judgments, 58 Indian Appeal and 51 Supreme Court, together with 1963 Supreme Court, the ends of justice have done.
Yes. Ex debito justiti is the
Yes,
principle.
that's right.
Yes.
That the Supreme Court has applied, that is Constitution bench.
Yes. And now again, I'm just inviting your attention on some of the arguments of Mr. Mitro.
Yes,
My
my
lord,
Lord.
may I humbly, my lord, make one suggestion to Mr. Mukherjee, if your lordship allows me.
Discreetly or openly?
Openly.
Okay.
If Mr. Mukherjee may consider
You
that
make the submission.
we really don't need the Order 41 Rule 27. We are before a probate court to decide on the execution.
It is up to you.
And
It is up to you.
yes,
You have to take a call. It's your baby.
it's up
You
to
have
Mr. Mukherjee to
your way.
I'm just suggesting whether we really need it or not.
My Lord, strictly we don't need it. Execution court, the probate court is concerned only with the execution and attestation of the particular will. Nothing more than. And it's a holograph will, little evidence will be enough. That I have made my submission already.
So don't press this application. The matter would end here and now.
Yes, Mr.
It's up-
Chatterjee. Mr. Chatterjee has drafted this petition and now he asks me to disown it.
Yes.
Mr. Chatterjee has drafted this petition and when I'm relying upon it, he asked me to disown it.
I have not, but it's for you to take a call whether we really need it or
Strictly
not.
speaking, it is not necessary. Your Lordship is concerned only with the
Right.
execution and attestation of the will in question. And holograph will, ex parte proceeding.
Mr. Mukherjee, you are correct. But since the point has been raised by Mr. Mitro, now you are also answering to that point which he has raised. So we have to give an answer to this because we have to decide it ultimately. So
Yes.
we go that what is the principle of law, what is required to be done in case of Order 41, Rule 27, additional evidence, to what extent the court will permit, what should be the recourses which are open to the court, and what recourses are the safest course. Everything we have to deal with it. And if you abandon it, we are happy. We will not go into these nuances of the
Well,
provision
I abandon. I abandon.
patterns. So we will not go into this. Yes. So no need to go for that. Now the second point which is argued by him was, if you come to page 43 of the paper book.
My Lord, kindly treat it as I am submitting. And it is not, rather than abandonment, it's not necessary, my Lord. Abandonment is a very hard expression, my Lord. Not necessary to go into that question in this proceeding. Therefore, your Lord will not go into
Because Order
abandonment.
23 Rule 1, I was just using that word, abandonment. Order 23 Rule 1.
That, my Lord, abandonment is a strong word.
Yes.
I'm not pressing that application now.
Yes. Yes, you come to this. The first paragraph says that in absence of any signature of the testator as well as attesting witness, in all those pages of the will in question, there is a justiciable ground to cast a doubt on the contents of the pages of the said will, which does not bear any signature of either testator or any attesting party. So what he says that, look, there is a doubt which is created in the mind, and it is a probate court is a court of conscience. If his conscience is not satisfied, then
That is-
so do you think that this reason is a reason for creating a doubt or the suspicion about
that
the
will be-
witness or a
that doubt will be justified in a non-holograph will. That doubt will not be there in a holograph will.
no? It
And
says
the-
both. It says not only the testator, but the attesting witness should also sign on all the pages. If you look
No,
at
that- that is not the requirement of law. That is not the requirement of law. They are amending the law. Attesting witness will only attest the signature of the testator at the last bit.
yes. And then what is your reaction to a last?
Kindly turn to that case. That case I've already cited.
Yes.
60 Calcutta.
Yes.
60 Calcutta.
Yes.
There's a, I do not know, Lord, was a law should still remember the judgment of Justice P.B. Mukherjee, sitting with Justice Bachawar, that in the case of a holograph will, the
Yeah, it's here. Yes.
kindly take that judgment into consideration. In the case of a holograph will, it will not be necessary.
1960 Calcutta, देखो तो.
551.
आगे देवा হয়েছে. देखो.
Is it?
Mr. Chatterjee has it. You give it to my lord.
Lord, we have one copy, my lord. আগেই দেওয়া আছে।
Yes. Yes. Paragraph 3, you were just trying to.
Paragraph 9 also. Paragraph 9 also.
Yes. Hey, you got that?
Mr. Chief,
Yes, we have given copies to the court.
Mr. Prasad has got a copy of it. Paragraph 9.
I think the best paragraph is paragraph 35 of that judgment. I do not know whether it will tally or not.
Yes.
Copy SCC has been given to me. Hey, why you have given a marked copy?
No, that is only what is left with us. We have given copies on the earlier occasion. Kindly excuse us.
Yes.
Only copy.
You have asked, excuse yourself earlier.
দেখো ভুল করে এখানে চলে আসে.
আমাকে ফাইলটা দাও আমি বার করে দিচ্ছি।
Have you come to a paragraph 35?
I'm reading paragraph 35.
Yes, very strong word.
Strong wording is given by the Privy Council.
Yes. Yes.
Is that the paragraph your lordship is looking at AIR?
No, SCC.
Acha. Is paragraph 35 your lordship is referring to begins a strong warning is given by the Privy Council.
What?
A strong in AIR paragraph 35 reads a strong warning is given by the Privy Council.
No. Just 1 minute. The strong warning you are reading.
That's paragraph 35 in the AIR.
That is a strong warning is given by the Privy Council in Charles
Yes.
Hart.
Yes.
No,
That's paragraph.
I'm telling you much earlier. May I read for you? The paragraph begins with this. A court, I'm just reading for you. A court of probate.
Para 22.
Para 20?
22.
Para 22 if you come.
Yes, a court of probate does not make a will of its own. The
Yes.
court is not the testator. Its function is to see if the will proposed with the propounder was duly made and executed with the capable testator. In order to do that, if the court of probate has to sit in the armchair of the testator, it has also to sit there with the mind of the testator and with the surrounding circumstances as
And the context
and
of the
context of the testator's family and other circumstances. Very that
other
that is
environment very much in the forefront of its deliberations.
elevation.
That is
And
the
it-
notion of armchair is introduced.
Armchair of the testator, my lord, is an expression which you often use, my lord, in probate matters.
Yes.
But that is with regard to the interpretation of the will.
Yes.
Execution and attestation of the will, my lord,
It has got nothing to do with that.
with that paragraph. That, my lord, paragraph, my lord, I was referring to is paragraph 9. Paragraph 9, my lord, in my AIR. Hmm? Eh? Hmm. The very first reason is paragraph 9 begins thus in AIR. The very first reason is that the will is a holograph will. That's how the paragraph begins. Para 9.
Yes.
Has the lordship got it, below?
Yes. You can read that paragraph.
The very first reason is that the will is a holograph will.
Yes. Paragraph 22. Yes.
The whole of the will was written in the hand by the testator himself in English. The handwriting is clear and firm. The law makes a great presumption in favor of the genuineness of a holograph will for the very good reason that the mind of the testator is physically written out.
Yes. Yes.
His own will is more apparent in a holograph will than where his signature alone appears in either a typed copy or to a script written by somebody else. The learned trial judge has not drawn this presumption in the case on what he says to be the ground that the testator was an old man in tune and was living under the shadow of the aggressive personality of Ajit. The testator was certainly an old man of 74 years while he was in Puri, but it is nobody's case. It was physically or mentally anyway incapable of making a will of their own. He went to Puri and lived there all in himself, without even his wife accompanying him. Holograph will has a presumption of its own. In every sentence, the intention of the testator is reflected.
Yes.
Your Lordship was asking me to deal with paragraph at page 43 of the judgment. But in the case of a holograph will, this consideration doesn't arise.
Yes. And then what about the last paragraph of that judgment? Can it be regarded as an incomplete and inconsistent document? At page 43, last paragraph of the judgment.
So considering the above disturbance in the said will in question, I find nothing convincing to rely on the said incomplete and inconsistent document. I don't find anything lacking in this will. Nothing is lacking in this will. The will only indicate his property is disposed of in such a particular fashion. The document is to take effect after the death of the testator. That makes the will complete. What is incomplete here? What is inconsistent here? Kindly will have a look at the doesn't say so. What is incomplete and inconsistent here? The judge doesn't say so.
What is your say? What is you have to say about this point taken by Mr. Mitro that the evidence of the plaintiff without an opportunity to contest, to cross-examine is null and void?
My lord, there is one principle. The principle is this. Right of cross-examination denied is a denial of the right of fair hearing, right of defense. It's violation of the principles of natural justice. I admit it. But the court, Supreme Court has laid down the violation of the principle of natural justice will be material if he is prejudiced thereby. He has allowed the matter to proceed ex parte. He didn't appear before the trial court. He has no case. He has not even been able to make out any case before Lordship, which he is going to put forward during the cross-examination. Unless, my Lord, kindly look at the two judgments I have in mind. In a revocation proceeding, there was no citation. The Supreme Court and the Calcutta High Court holding, yes, there is no citation. But I will not cite the I will not revoke the grant unless you satisfy the conscience of the court that you are seriously prejudiced by here. What is the prejudice here in this case? You have not appeared as a trial court. You have not made out any case. You will prejudice the absence of cross-examination. দেখে তো করুণা করে judgment out. I am referring to a judgment, to celebrated judgment of the Supreme Court. I give your lordship the context of that judgment.
No.
Your lordship will.
On a different note, there are judgments because previously the principle of odi alteram partem was considered to be a inviolable, or inflexible right. Nobody can be denied of an opportunity of hearing. But later on, there has been a little shift, may I say, from there. It says that every violation of odi alteram partem does not mean that the order or the decision is bad, unless the prejudice is shown. And if you are not prejudiced by this, then you cannot come forward and say that it is violative of the
and the order on the challenge is to be set aside. Have you not kindly look at the judgment?
Quite conscious of those proposition in that way. And
I'm grateful to your lordship.
the third one recently came that if the statute provides that there should not be any opportunity, then
There is no
also
question of violation. My lord, I am referring to the second principle. Kindly look at this. Paragraph 31.
well-known judgment. This is a well-known judgment. Yes.
I have said, my lord, this is a well-known judgment. Paragraph 31. Kindly refresh your mind. Paragraph 31. অরিজিৎ পাশাওয়াতের বাদ এই লেখা আছে
Yes.
My lord, this passage has been referred to by the Supreme Court approvingly in a subsequent judgment of Justice Dr. Arijit Paswar, that's reported in 2009 Supreme Court. This is Karunakar itself is a famous judgment.
Yes.
Earlier judgment I have cited before lordship, famous. And unless you can.
Oft-quoted judgment, which is often used and is a foundation actually.
Yes. And Justice Paswar, my lord.
So what is a castle which has been built thereupon?
Bigger lordship, pardon.
That is a foundation, but where is a castle which is built thereupon? The
This,
latest.
my lord, is the present stand taken by the court. Unless you satisfy me about your prejudice, I will not allow you to succeed on a technical ground of non-service or not providing an opportunity.
Yes.
As the castle now is existing, as the castle now respected with the court.
Yes.
Merely saying that I have not been given an opportunity. What is the opportunity you want for? What are you going to suggest during cross examination?
Yes. You were citing 2009?
9 Milon, Supreme Court, 161, paragraph 7.
AIR.
AIR 2009, Supreme Court, 161, paragraph 7. Approvingly quoted from this Karunakar judgment. My lord, that is also, my lord, kindly look at the judgment of this Honorable Court. That's Sanjeev Banerjee dealing with an application on Article 260, Section 263 of the Succession Act, revocation. Non-citation was accepted, but the court held that mere non-citation will not entitle you to have the probate revoked. That is then reported in 2017 1 judgment 2017 1 CLG 201 Calcutta Lottery. CLT chato. CLT 2001
CLT or CLJ?
CLT
CLT. Calcutta Law Times.
Law Times.
Yes.
Age?
Page my lord 201.
Give me 1 second.
There was no citation. He was complaining about non-citation, seeking revocation of the will. The court said, what is your prejudice? Satisfy me, otherwise I will not revoke. Kindly have a look at this judgment.
ওখান থেকে মিল
Short judgment. Para Supreme Result.
Hmm. Yes, this is, I think, after quotation in paragraph 30. I think the relevant portion is the omission to issue citation to a persons who have been apprised of the probate proceeding may well be in a normal case a ground itself for revocation of grant. But this is not an absolute right. It's irrespective of other consideration arising from approved facts of the case. The law has vested a judicial discretion in the court to revoke a grant where the court may have prima facie reasons to believe that it was necessary to have the will proved afresh in presence of the interested party. But in the present case, we are not satisfied that all such circumstances. This is what it says.
Yes. In spite of non-citation, refused to revoke.
Obviously. Yes. Anything more?
My lord, there is also a Supreme Court judgment That's reported in 2017. I'm sorry, maybe 2018. One Supreme Court cases, 271.
Wait a minute.
Well, in section 263, the ground for revocation is whether a just cause. The court said in spite of some omission, there will be no revocation unless a just cause is established. And just cause is defined to mean a defect of such a character as to substantially affect the regularity and correctness of the proceedings.
Yes.
Here also the Supreme Court is pointing out no prejudice to you.
Paragraph 14. Yes.
Mr. Chatterjee, anything else? I wanted only an hour and a half. I've completed within an hour and a half.
Exactly our, exactly.
Grateful Lordship.
Sir, they have filed a cross appeal after the after 4.5 years of service of appeal.
Without limitation.
Yes,
We haven't pressed it.
they haven't pressed it yet, but they have filed.
কি হয়েছে? কি হলো?
ওরা ফাইল করেছিল যেটা ওরা প্রেস করেনি, তা আমরা বেকার আর্গুমেন্ট করবো কেন?
কোনটা?
ক্রস অ্যাপিল।
Cross appeal.
ক্রস অ্যাপিল ছেড়ে দে, ক্রস অ্যাপিলটা আমার বলবো তোকে।
Cross objection.
You
Cross
haven't-
objection has
you
no
haven't-
limitation.
They haven't placed.
We are on order 21, order 41, rule 22.
So they have,
They can support the judgment and their appeal on some other ground. That is admitted.
and also,
Also, yes,
they can challenge.
without filing a cross objection.
Yes. Your own
Correct.
argument, tide water. In a tide water case, 82 Calcutta, you have argued.
I don't remember.
You should.
My lord, we are not pressing that appeal.
Oh, he is not pressing the cross objection.
Yes.
So you are not pressing your order 41 rule 27.
I was trying to tone it down, my lord, in some abandonment.
Yes. Hearing,
Shall be giving a written notes of argument. We shall be giving a written notes of argument.
What is my big God?
give whatever you want to give.
And so far as
We
the
will not
judgment,
prevent.
new judgments have been cited, my lord, kindly give a date, my lord, which are distinguish the judgments.
What he will do? He has
Keep it-
basically cited on order 41 rule 27. Later
No,
on, he
argument on prejudice, my lord, argument has been led, my lord. That is very, very vital argument.
what a vital argument.
Is it unknown to you? Is
Well,
it unknown to you?
Without notice, the probate can be granted. That is the argument ultimately Justice Banerjee has held.
No. He never said. This is the first principle is because the ground under section 263 is that if there is no citation, that is one of the ground for the purpose of revocation of a grant of probate. But the law which has advanced is that mere non-citation invalidates the grant. No, it says the prejudice has to be
That is
shown.
exactly what I am
If
saying.
there is no prejudice which is caused,
The element-
then in that event, non-citation
No.
takes a backseat.
Yes, that is the element
Nothing.
of prejudice is there or not, my
Not-
lord, these
it's
judgments
not.
will be, my lord, dealt with us.
Sir, the only thing is we are concerned with the appeal against an order rejecting an application for probate. You have to consider that. I think that's a sufficient hint which has been given.
Keep it tomorrow as to be mentioned.
What for?
For this distinguishing of judgments.
Distinguishing the judgment what? You will argue.
I have merely made your point, nothing more.
No. Justice Sanjeev Banerjee judgment was not shown. Other Supreme Court
That is
were
on
not
the
shown.
revocation.
2017.
What hint I gave you?
Are you admitting your appeal, but disowning it? Mr. Bhattacharya, kindly tell or inform the Honorable Court. Are you disputing, disowning the will in your favor? You have admitted the will in your favor.
That will is not a part of the record. Therefore, I cannot make any comment on
Not answering the question.
but you have withdrawn it. Order for the Rule 27, you have withdrawn. You have withdrawn, yes or no? Answer is right.
I have withdrawn in my wisdom.
It's a stand of your client.
But are you
Not in
disowning the will?
Keep my stand. Let him lead the evidence.
Telephone.
Mr. Mitra wanted me. He has left the court tomorrow
Come
anytime.
tomorrow, but not
2 p.m.
beyond
Beyond 2 p.m.
No, come at 10:30, but not beyond 10:45.
10:45. 10:45. He is coming, old man. He is coming. Not that he is sitting at home, my lord, and doing in virtual.
Okay.
He is coming
Then
physically.
we are fixing at 12:45, and we'll have to finish at by 1:50.
As well.
And the written argument must be given in this course of this week.
Yes. That we shall be giving. Grateful. Chup kar na.
In course of this week.
In course of this week, we shall give that.
And also, we'll also file them.
Kalke 12:45.
Can no.
Yes.
Great Your Lordship.
Tomorrow.
No, we shall not file any written notes of argument, my lord. Mr. Mukherjee has made a submission.
But
That's
your
it. We shall
junior
not
is
file.
saying something, your senior
no.
is saying something, then you intervene, says another thing.
No,
What
my
is
lord, Mr. Mukherjee, whoever drafts it, Mr. Mukherjee shall not draft it. The impact will be lessened. My lord, I don't want any written notes of argument from my side. His argument is that's it.
Yes. Yes, what is the next matter?
Next matter, your lordship, can you remembers that matter? Indian citizens after marriage migrated to Australia, became Australian citizen. Wife came back to India. Husband subsequently came back. They applied for divorce on consent. That the rules of OCI, though your lordship remembers, it has not been properly construed by the learned.
আমি এখন হাইকে কিন্তু সবচেয়ে বয়স আমার তো বয়স থেকে ওয়াই করে পাঠিয়েছে
না সেটা ঠিক একদম
90
একদম
বল ভাই আর একটা বুকের বাঁ দিকটা কাজ করে আমার লাংসের অর্ধেকটা কাজ করে
আপনি বলেছিলেন আমার মনে গেছে
60টা সিগারেট 30 বছর খেয়েছি এই জানেন ক্যান্সার হসপিটালটা কি ভদ্রলোক হ্যাঁ নাম করা ভদ্রলোক ক্যান্সার হসপিটাল করেছেন দক্ষিণ কলকাতায়
মহিলা
বাঙালি ভদ্রলোক কি জানেন রাস্তার জায়গাটার নাম আছে আমার মক্কেল সে এসে ডাক্তার এসে প্রথম আমার দিকটা ঠিক আছে তো ঠিক আছে রোজ 500 টাকার সিগারেট খেয়েছি ভালো সিগারেট খেতাম 500 টাকার সিগারেট একটা সংসারে হপ্তার খরচা 500 টাকা এই যে কি নাম ছিল যে ক্যান্সারের ডাক্তার আমার মক্কেল ছিল যে ক্যান্সার কি নাম হ্যাঁ হসপিটাল করেছে এসেই আমাদের এটা ঠিক আছে
মামলা করেছে
আচ্ছা স্যার
ছেলে এখন টপ ক্যান্সার হসপিটাল বিল্লাল টাটার টপ কনসালটেন্ট ছেলে এখানে কলকাতার টপে ক্যান্সার নিয়ে টপ এই দক্ষিণ কলকাতা এই সল্ট লেকের টাটার হসপিটাল করেছে না? কি গুরুত্ব আছে অমিও গুরুত্ব দেন।
আচ্ছা আচ্ছা
সেটা